There is a judgment.
This is judgment.
Judgments.
I'm so sorry. In my case,
All right, how many are for mentioning?
My lord.
Tell me one thing, all partial working days, there are at least 3 to 4 benches available. All urgent matters will be heard.
I want my matter to be heard on day after because the order is one of the 30th, it will become insured. So
No, no, it's all right. Those who have an extraordinary urgency for day after, please give your letter of urgency. We will examine and we'll list those matters.
Yes, we-
Rest, all other matters will be listed in the very first week.
That's right, but we'll do that, Lords.
Some peculiar.
My lords, my mentioning was allowed on Monday. However, certain defects, I closed it right now. My dealing person was on leave. I closed it right now. My lords, I have an apprehension. My case will go into insolvency. Mine is a regular bail matter.
Okay, mine is demolition. Demolition date is 30th. Yesterday I mentioned before your lordship, I removed the defect. Now it is SLP number 19250 2026 on Friday.
There is some issue of caveat proof or something you have to.
That we have done. We have done, lordship.
If that is done, then we will list.
There's one matter,
My lord.
may I submit, my Lords? In my matter, the petitioner is in a critical position. Right now, bedridden with hospice care at home. So, Lords, she may not be able to see the listing of this matter post vacations. If your Lordship would kindly.
Mention, we hope that you must mention all these reasons. Oral mentioning will not serve. If you have mentioned anything attached to, so we'll examine, we are saying so.
I'm obliged.
Lords,
There's one matter, my Lords. Would your Lordship just,
Any good reason for urgency of this nature that the matter must be heard day after, please give it, we'll examine it.
I'm obliged.
Otherwise, all matters of, in any case, routine urgency, within 2 days are to be listed, subject to curing the. 2 days means in the week commencing on 1st June onwards, we will list it. But if you have any special, not on instead of first, we can adjust that much. So there is no.
My lords.
I'm so sorry, my Lord. May I?
Only one request, which may not fall within my lord usual urgency. Could have issued notices on the challenge to the
Take the mic, please.
transgender sect. My lords have issued notices. Look, there are 3 or 4 high courts also where petitions are filed. We have filed transfer petitions. Now, in the high court, those matters would be coming in the first week of June because some high courts are reopening in the first week of June. So, if the transfer petition, my lord, can be listed on Friday, my lords.
On?
Friday, my lord. Only transfer petition because same act is challenged in high court also.
You know, it's not a small matter that they will be able to decide in a day or so. Assuming they decide, we will have the advantage.
There are some, my lord, interim orders being praised, etc. my lord. Even if a notice goes, my lord, we will be able to say that please wait till the Supreme Court finally adjudicates.
So that very act is under challenge.
The very act, my lord.
But sometimes we have the advantage of the High Court opinion also.
Well, there are 4 high courts where the matters are pending. There would be divergence of views. It's better, my lord, that your lordship finally can.
To help us in taking the correct way.
Lord, we may persuade your lordship, Lord, if it can be listed on Friday.
We'll see.
Please.
My lords,
Because
my
that-
lords, mine is listing today, my lords. This is a challenge to the CBSE's 3-language policy. My petition is already numbered. These are petitions by EVS category students and their parents. If they can be taken with item 46, my petitions are already
Lord,
numbered.
I am appearing there, but there Delhi High Court is seized of this issue. There is a 226 petition challenging the same policy. We'll point it.
My lords, if my petitions can be called out, otherwise I have copies of my
To
petition.
be here,
Please, ma'am.
otherwise it will be very difficult for the registry also to process it.
I have copies also.
You may be here, if any
Please.
additional point, we can hear you also. Not-
Grateful.
Because there's a matter where we'll provide the mentioning memo for Friday. Judgment rendered yesterday. I was on interim bail. My regular bail has been rejected. I've been directed to surrender within 3 days. Because I'll request for Friday. I'll place that mentioning memo before your lordship's done.
No, what is the urgency?
But the urgency is this. I was arrested on 23rd of December. Within 4 days, out of abject falsity of the matter, I was granted interim bail by the court from 27th of December. That interim bail was continuing. Yesterday at 7 p.m., the judgment rejecting my regular bail has come out, and I've been directed to surrender.
Well listed.
I am most.
Item 27, the lordships, there are applications for withdrawal. This is that Himanshu Singh matter, lordships.
Item?
27 today, your lordship. I matter, your lordships could not be.
wants to.
No, it's not listed. It's tagged with it, but not listed. I'm just asking them to call for the file at 27. We'll be here at item 27.
You want to withdraw that?
Yes, your lordships.
In any case, we allowed, what is is it conditional withdrawal?
Condition is complete payment, your lordships. We are doing that. So lordships, the registry may just send the file to your lordships.
Himanshu Singh matter.
Item 27.
Because we have taken.
That's the reason I'm requesting your lordships to call for the file, because your lordships, it's a standalone. There's only one homeowner. There's nobody else in my project. That's the reason. So if your lordships just directs them to call for the file, we'll address your lordships at item 27.
We'll see that there is no urgency for withdrawal today. sir.
Your lordships, because the scheme ends on 30th. That is the reason. On 29th.
But
We'll be here, your lordships, at 27.
So, this year, we have some very serious doubts on the.
Yes, your lordship.
Why somebody is withdrawing that? Must
Yes,
be
your
because
lordships. So,
Builder network must be working.
yes, that's the reason why your lordships has to look at it. So I'm requesting them to just bring the file. We'll show to your lordships what it is. Yes, grateful.
Malaj,
Your
I
Honor, with
permitted to
due
make a
permission.
mention, Malaj. Malaj, the Bihar municipal elections, Malaj, the elections have been held without the appointment of a backward commission, Malaj, and the seats have been reserved. Malaj, this is pending since 2024.
Election have already been held.
Yes, Malaj.
Then what is the urgency, please tell me?
Malaj, the urgency is that it is on the brinks of being rendered infructuous because the term is going to end in 2027, Malaj.
We will see, please. Don't
Malaj, if
create
your lordship,
artificial urgency.
Malaj, your lordship are sitting in the third week, Malaj, if your lordship may have it.
How can all the, do you expect that all matters can be
Malaj,
heard in?
thrice, Malaj, this Malaj has been listed, Malaj.
We will see what is the.
Malaj, I'll just pass on the urgency letter. Yeah, I'm so grateful, Malaj.
Football Federation matter. So we are one of the clubs who has in the
All India?
All India board. No, in this case, we are one of the clubs who has been dedicated.
All luxury litigation.
Lordship, I only request that we should be implemented and.
All these processes. So what is the urgency now?
The urgency, Lordship, we have been already relegated. Now we can't participate in next season. We can't have any investors.
We will see what can be
We
done.
moved the urgency for both implement as well as direction, Lordship.
We will see. This can be added during vacations also, no difficulty.
Your
Lordship, with due permission, I want to submit in one press matter, Your Honor, where the Dr. Suraj Singh has mentioned that a demolition has been, Your Honor, my petition is the connected matter, Your Honor.
All right, that can be listed.
Yes.
There was issue that some caveat proof was required. So there is.
Your Honor, that has been cleared, Your Honor.
Please comply with that. Those, both matters can be listed there.
Yes, sure.
Your Lordship, this is a civil appeal against NCLAT order and the NCLT order of CRP remains operative. We had mentioned on Monday, it was to be listed today. However, the dealing person who had to check our appeal was on leave, so it could not be get cleared and mentioned. So it's requested that it may be listed on 29th because
Yes.
there's an imminent danger of going into liquidation.
May it please your lordship, my matter is similar. I also want to list my IA for withdrawal in Prakash Singh versus Union of India, which is item 54.
In Prakash Singh was chairman of.
Yes, we have filed an IA for withdrawal of intervention application by IA number 159602.
Who is the applicant?
We are the applicant. We have
What is your status? Who are you? Just we want to know. Are you in Prakash Singh that DGP matter?
DGP matter, my lord, he moved application for IA for
Who is
intervention.
the applicant? We want to know that.
Sandeep Singh Rathore, my lord, Sandeep Singh Rathore,
Some individual is there.
individual person. We want to withdraw the
He
matter.
was asking for earlier.
My lord,
What was the relief he sought
my lord,
earlier?
during that point of time, my lord, his name is not in the panel list, my lord, for that.
Wanting consideration.
My lord, for we all, now the name is included, my lord, his name is included. So we want to withdraw the IA, my lord, that's it. My lord.
All right, all right. Whenever it will be listed, we will.
Right. Prakash Singh is listed today, my lord. My IA is not there. Even I wrote a letter to the registry to withdraw.
Prakash Singh matter is not listed, sir.
54, my lord.
If it is.
54, my lord.
Item 54.
Because main case is not only Manipur IA is there because they have last 1 week they are making some mentioning about
urgency.
Just a withdrawal, my lord, may be allowed, may taken up a board and withdrawal, my lord, that's all.
Your application note earlier, you should have mentioned it. We can't take a bill along with this. We'll see.
Otherwise, direct the register, it may be listed before the register court, my lord, register will allow
The
the.
particulars of your IA, we'll see.
Yes,
उसको लगा के start करो.
always.
Lordship, my Lordship, in petition 581, we have filed a co-option proposal. Yeah, mentioning letter also, but they are not listing in that. So 29th, Vardhan matter is listed.
Bar council matters are over now. What?
No, my lord, Vardhan matter is listed on 29th. It's showing 29th.
We will see along with other matters. We'll take up.
Milords, may I mention, Milords, one listing of a fresh review petition, because I have to, I was supposed to surrender in 1 month.
Do the mic.
And Milords, actually my bail application, I was granted bail by High Court, and this honorable court had thereafter directed them to rehear the matter. Now I have filed review petition and I have to surrender in 1 month. So Milords, 1 month will be expiring in June, so I have filed a review petition.
So which bench has passed the order?
Milords, Honorable Justice Pankaj Mittal and one more, Milords, I do not remember, Milords.
No, you are asking review in a criminal matter. We don't know whether.
I have, Milords, review has been filed, but defects have been not marked. So, Milords, may direct the registry to get it expedited and listed thereafter.
It can to be circulated only. Review is not listed on open court. Unless the bench will direct.
Please, Milords, so at least can be listed either before the chamber court or circulation. I have moved an application for open hearing also.
Before the same bench.
Grateful, Milords.
Permission, I want to mention an urgent listing of the matter on 29th. It's a land acquisition matter, Your Lordship. The High Court in the contempt proceedings is going to frame charges against the acquiring body officer on 4th of June. Your Lordship may kindly allow the matter has already been cleared. All the defects have been cleared.
Who are you?
I'm the acquiring body officer of the acquiring body.
And why the High Court has summoned?
Your Lordship, the entire decretal amount has already been deposited and it has been
Go and
dispersed.
explain to the High Court.
Your Lordship, we have already explained they are proceeding against the.
Go and file an affidavit of compliance.
They are taking a different.
Sorry, there is no urgency.
Lordships, my apologies. May I mention 28, 25 and 25.2, which is listed today. Both were taken up on 4th May and Lordships had given a date for 21st of July. I'm just requesting if those can be listed on 21st itself. They were a date given matter. There were time for the Lokpal to file a rejoinder and complete pleadings.
Piece of paper, you can write down that same matter to be on 21st July.
I'll do that.
Lordship, if I mention a matter, with your Lordship's permission, may I mention a matter? It's an anticipatory bail matter, my lords, for offences under 504 and 506. The subject FIR was a cross FIR. We have filed on 24th. We have cleared the defects yesterday only, my lord. However, the registry has not cleared it. That's why it could not be listed, my lords. So my lords can allow it for the listing on Friday.
It has not been listed. There must be some reason.
We have cleared the defects. However, they have not cleared it. The registry has not cleared it. That's why it was not cleared for the listing, my lord.
We'll check up.
Grateful.
501 for adjustment.
Please, that batch of petitions instituted under 32 of the Constitution assailing the impugned order directing SIR in Bihar. Can we have shortlisted the controversy that the controversy emanates from the issuance of the impugned order by the Commission in purported exercise of its powers under Article 324 of the Constitution, that is Section 21, subsection 3 of the Representation of the People Act 1950, directing an SIR of the electoral rolls in every assembly constituency of the state of Bihar. The impugned order reported that the last intensive revision in the state of Bihar was conducted in 2003, and that over the past 2 decades, substantial changes in electoral rolls have occurred entirely on account of rapid urbanization and large-scale migration. Therefore, in furtherance of its constitutional mandate to safeguard the integrity of the electoral rolls and ensure free and fair election, the Commission resolved to undertake the nationwide SIR. Given that general elections to the Bihar Legislative Assembly were anticipated later in 25, the Commission directed the conduct of SIR in the state of Bihar. Then we have after the referring to the rival contentions from both sides, then we have said that having traversed the sequence of events as they emanated, the contentions put forth on behalf of the parties as well as material on record, we are of the consideration that the following issues require analysis. First is whether the Election Commission of India has power to conduct the impugned SIR. Second, whether the impugned SIR is founded on a legitimate purpose, and if so, whether the measures adopted by the Election Commission are proportionate to the object sought to be achieved. Third is whether the procedure adopted by Election Commission in conducting the impugned SIR is contrary to or in violation of the provisions of the Representation of People Act 1950 and the registration of Electoral Rules 1960. The fourth question is whether in the exercise of its constitutional mandate of preparation and maintenance of electoral rolls and in furtherance of the statutory conditions governing such registration, the Election Commission of India is empowered to scrutinize the citizenship status of persons seeking inclusion or continuation in the electoral roll. As regard to the first issue, whether the Election Commission of India has power to conduct the impugned special intensive revision, we have considered the contentions and then our brief findings are that having deconstructed section 23 and examined the import of the consequent expressions, we may now proceed to answer the limited question formulated earlier by us, namely whether the impugned order is in direct conflict with the RP Act and the 1960 rules and whether affect the directly affect the RP Act and the 1960 rules and whether its operation and effect it subserves the constitutional goal of free and fair elections. In our view, both limbs of the question must be answered in favor of the Commission. Far from acting in defiance of the RP Act and the 1960 rule, the Commission has squarely anchored its actions in a specific enabling provision designed by Parliament for exceptional exigencies polluting the electoral process. Section 21(3) couched in terms materially distinct from 21(2) authorizes the Commission not only a regime of revision to direct a special revision at any time for reasons to be recorded and in such manner as it may think fit. Once the statute itself carves out that special field of operation, the impugned exercise cannot be invalidated merely because it does not conform in every respect to the ordinary modalities contemplated for revision under section 21(2) read with rule 25. In our considered opinion, the impugned SIR does not supplant the RP Act or the 1960 rules. It rather breathes life into the constitutional mandate of Article 324 through the precise statutory conduit provided by section 21(3). Therefore, it cannot be said that the Commission has acted in the teeth of an express statutory provision. So long as the Commission acts within the bounds of the statute, records reasons for recourse to the special power, and does not transgress any express prohibition contained in the Act or the rules, the exercise cannot be struck down as ultra vires merely because it adopts a procedure different from that applicable to ordinary revision of electoral rules. We are equally satisfied that in its object and design, the impugned SIR bears a direct nexus to the constitutional goal of a free and fair election. Free and fair elections do not rest merely upon the mechanics of polling. They equally depend upon the integrity, accuracy, and purity of the electoral roll, which forms part of the foundation of the democratic process. The reasons reported by the Commission, namely the passage of more than 2 decades since the last intensive revision, large-scale additions and deletions over the period, rapid urbanization, migration, and the resulting possibility of repeated or defective entries are plainly directed toward preserving that foundational integrity. The impugned SIR, therefore, is not a process designed to subvert the established procedure, but an intended to secure the constitutional mandate of free and fair elections. For the aforesaid reason, we hold that the impugned SIR neither stands in direct conflict with the RP Act and the 1960 rules, nor does it detract from the constitutional imperative of free and fair elections. On the question number 2, whether the impugned SIR is founded on a legitimate purpose and if so, whether the measures adopted by ECI are proportionate to the object sought to be achieved, we have considered this aspect in detail and we found that this question needs to be divided in 4 sub-questions. In view of the rival submissions advanced on behalf of the parties, the following 4 questions arise for consideration with respect to the proportionality of the impugned SIR exercise. First is whether the impugned SIR is founded upon a legitimate purpose consistent with the constitutional and statutory mandate of the Commission. Second is whether the means adopted by the Commission bear a rational nexus and the object sought to be achieved. Third is whether the measures undertaken were necessary in that there are no alternative measures that can achieve the same purpose with a lesser degree of limitation. And fourth, is there a fair balance between the importance of achieving the proper purpose and the limitation it places upon the constitutional right. Then all these 4 issues we have examined in detail, reaching to a conclusion to say that the proportionality of a measure must ultimately be assessed not in the abstract but in the manner in which it is implemented, a process that may be perceived as exclusively by some can, through appropriate safeguards, be rendered constitutionally compliant in execution. In the present case, the cumulative effect of the safeguards introduced both by the Commission and pursuant to the directions of this court. We have before that dealt with all interim directions issued from time to time, and pursuant to the directions of this court has been to strike a balance between the need for electoral integrity and the imperative of inclusion. The process, as it ultimately unfolded, provided multiple avenues for participation, correction, and redress. We are therefore of the conclusion that the impugned SIR has conducted satisfy the requirements of proportionality. The measures adopted bear a rational nexus to the object sought to be achieved, are not manifestly excessive, and are accompanied by sufficient procedural safeguards to prevent arbitrary exclusion. In view of the foregoing analysis, we hold that the impugned exercise was founded upon a legitimate and constitutionally grounded purpose, namely the restoration of accuracy, completeness, and integrity of the electoral rolls. We further hold that having regard to the nature of the problem sought to be addressed, the scale of the exercise undertaken, and the procedural safeguards incorporated during its implementation, the measures adopted by the Commission cannot be said to be disproportionate to the object sought to be achieved. On the third question, namely whether the SRA is contrary and violative of provisions of the Representation of the People Act 1950 and the registration of the Electors Roll 1960, we have said that having held that the impugned SIR is legally tenable and pursues a legitimate purpose, we now proceed to examine whether the procedure adopted by the Commission is in derogation of the provisions of the RP Act and the 1960 rules. This question also we have sub-classified in 3 categories. That we have said that 3 principal grounds have been asked before us by the petitioners, namely 1, the electors whose names are already entered in the electoral roll are entitled to a presumption of citizenship, which cannot be displaced save in accordance with procedure established by law. 2, that the procedure contemplated under Rule 21 capital A of the Registration of Electors Rule 1960 has not been followed. And 3, that the documents prescribed by the Commission for the enumeration of the electors coupled with the exclusion of previously accepted documents are arbitrary and without any reasonable justification. Then we have analyzed these 3 categories. We have also dealt with Lal Babu Hussain from para 108 onwards. And we have ultimately concluded that we are also unable to accept the submission that the undertaking of an intensive verification exercise ipso facto reverses the burden of proof in a manner impermissible in law. The calling upon electors to furnish supporting material in course of such an exercise does not amount to the negation of the presumption. Rather, it reflects the procedural mechanism through which the Commission seeks to reaffirm or, where necessary, correct existing entries. The presumption continues to operate, but it does not obviate the possibility of verification. It is also significant that in Lal Babu Hussain, this court did not hold that the presumption attaching to an entry in the electoral roll is irrebuttable. On the contrary, the very recognition of the presumption implies its susceptibility to being displaced upon appropriate inquiry. What the judgment underscores is the need for adherence to procedure and fairness in the process of displacement. It does not foreclose the existence of such a process altogether. And after that, we have said we are thus of the considered view that while inclusion in the electoral roll gives rise to a presumption of validity, such presumption is rebuttable and cannot be construed as imposing a blanket embargo on the powers of the Commission to undertake a special intensive revision. The decision in Lal Babu Hussain does a contrary conclusion being confined to the extent of adjudicatory proceedings. With respect to Rule 21A, also then we have given a detailed discussion, and then we have concluded, viewed holistically, the scheme underlying the SIR guidelines revealed that the safeguard embedded in Rule 21A of the 1960 rules have not been abrogated but are instead operationalized within a broader and structured revision framework. The essential elements of Rule 21 of the 60 rules, namely identification of doubtful entries, publication of such cases, notice to the concerned elector, and a determination after considering objections, find clear reflection across the various stages of the SIR process. The form may differ, but the substance remains intact. In particular, what Rule 21A of the 60 rules contemplates as a singular event-specific exercise of deletion is under the SIR framework distributed across multiple procedural stages, beginning with enumeration, followed by draft publication, and culminating in the claims and objections process. It is at this later stage that the core safeguards are activated. The elector is put to notice and inquiry is undertaken where doubt exists, and a reasoned determination is made. The requirement of affording a reasonable opportunity to show cause as envisaged in the proviso to Rule 21A of the 1960 rules thus stands fully incorporated. It must also be borne in mind that the statutory framework does not mandate a rigid or singular procedural format for all situations of deletion. What it insists upon is the SIR guidelines in incorporating notice through publication, individualized inquiry in case of doubts, a speaking order, and a right of appeal satisfy this requirement. To construe Rule 21A of the 1960 rules as requiring a uniform pre-decisional notice at the very threshold, irrespective of the structure of the exercise, would be read the provision in unduly restrictive manner. We are therefore of the considered view that the deletions effected pursuant to the implemented SIR cannot be said to be contrary to the procedure prescribed under Rule 21A of the 1960 rules. The safeguards of notice and hearing are preserved in substance, and the process adopted by Commission remains within the bounds of the statutory mandate. Then we have dealt with the validity of the documents regime prescribed by the Commission as part of enumeration exercise. After dealing with those 11 documents which they said, and after referring to the inclusion of Aadhaar card through our order passed in detail, then we have said we have bestowed our careful consideration upon the rival submissions advanced on this issue. The challenge, in essence, is directed not merely at the nature of the documents prescribed, but at the authority of the Commission to structure a documentation regime as part of an intensive verification exercise. We are unable to accept the contention that the prescription of such a regime in the facts of the present case is arbitrary or behoves the statutory framework. In that context, the prescription of the set of documents operate as a tool to ensure administrative consistency and evidentiary reliability. It is neither practicable nor desirable for the verification process to be left entirely unguided or subjective. It is true that Form 6, as prescribed under the Registration of Electoral Rules 1960, sets out a framework of documentation. However, the same is tailored to the process of revision contemplated in Section 21(2) of the RP Act and may not, in all situations, be capable of literal application to an exercise of the present nature, namely SIR, under 21(3). The Commission therefore retains a degree of residual authority to formulate an appropriate documentation framework suited to the exigencies of a special intensive revision. Such authority, however, is not unbounded. In devising such a framework, the Commission must remain cognizant of the existing statutory scheme, and any departure therefrom must be informed by a rational nexus to the object sought to be achieved. The formulation of the documents regime must thus reflect a calibrated balance in drawing from the statutory framework while adopting it when necessary to effectively serve the purpose of ensuring the accuracy and integrity of the electoral rolls. A perusal of the documentation framework suggests that the list of documents is indicative of materials that are ordinarily available to electors. The expansion of the list as compared to earlier exercises also demonstrates an attempt to widen the range of acceptable proofs rather than to restrict it. The argument that the regime is exclusionary, therefore does not commend acceptance in the absence of material to show that the prescribed documents are, by their very nature, inaccessible. Then on the fourth question, the existence of the constitutional mandate of preparation and maintenance of electoral rolls and in furtherance of the statutory conditions governing such restriction, whether the election commission is empowered to scrutinize the citizens' status of the person seeking inclusion or continuation in electoral rolls. This part we have discussed in detail and come to the conclusion that in view of the statutory requirement under section 16 of the Representation of People Act, the Commission in the course of preparing or revising electoral rolls is undoubtedly empowered to examine questions bearing upon citizenship. However, such an inquiry can only be made from the standpoint of determining inclusion or exclusion from the electoral roll and must be undertaken with due regard to the presumption operating in favor of an elector whose name is already borne on the roll. It is within this confined statutory setting that the Commission assesses the material before it to arrive at a determination for electoral purposes. Importantly, the entirety of this exercise remains amenable to judicial review, thereby ensuring that the inquiry is conducted in accordance with law and within the bounds of the procedural fairness. We have no hesitation in adding that this assessment is necessarily prima facie and contextual, where the material furnished by an individual does not inspire confidence or give rise to doubt. The Commission is within its authority to decline enrollment or to initiate action for deletion strictly in accordance with law. Such action, however, must be understood in its proper perspective. It does not amount to a declaration that the individual is not a citizen of India. It merely reflects the Commission's inability to be satisfied for electoral purposes that the statutory conditions are met. The consequence of such a determination is correspondingly limited. It affects the individual's entitlement to be included in the electoral roll and thereby their right to participate in the electoral process. It does not, however, operate to divest the individual of claims of citizenship, nor does it foreclose a determination of that question by the competent authority under the Citizenship Act. Moreover, in cases where the Commission is not satisfied that a person meets the statutory conditions for inclusion in the electoral roll, it would be incumbent upon the Commission to refer such an individual to the competent authority within the central government for adjudication in accordance with law. The Commission's determination, being confined to electoral purposes, cannot assume finality on the question of citizenship. Any deletion effected on this ground shall therefore remain subject to the outcome of such adjudication by the appropriate authority. So based upon these questions to answer to the four questions, we have summed up by saying that the impugned SIR exercise neither stands in direct conflict with RPF and the 1960 rules, nor does it detract from the constitutional imperative of free and fair elections. It is instead an exercise traceable to section 21(3) of the RPF, read with Article 324 of the Constitution, undertaken to advance the very objective of which part 15 of the Constitution is designed to protect. To the impugned SIR exercise as conducted satisfy the requirements of proportionality. The measures adopted via a rational nexus to the objective sought to be achieved are not manifestly excessive and are accompanied by sufficient procedural safeguards to prevent arbitrary exclusion. The impugned exercise was founded upon a legitimate and constitutionally grounded purpose, namely the restoration of the accuracy, completeness, and integrity of the electoral rolls. Having regard to the nature of the problem sought to be addressed, the scale of the exercise undertaken, and the procedural safeguards incorporated during the implementation, the measures adopted by the Commission cannot be said to be disproportionate to the object sought to be achieved. While inclusion in the electoral roll gives rise to a presumption of debatable and can be considered as imposing a blanket embargo on the power of the Commission to undertake a special intensive revision. The decision in Lal Babu Hussain does not compel a contrary conclusion, being confined to the context of adjudicatory proceedings and not extending to a systemic exercise undertaken in furtherance of the Commission's constitutional mandate. The deletions effected effective pursuant to the impugned SIR exercise cannot be said to be contrary to the procedure prescribed under Rule 21A of the 1960 rules. The safeguards of notice and hearing are preserved in substance, and the process adopted by the Commission remains within the bounds of the statutory mandate. The documentation regime prescribed by the Commission represents a considered exercise of its administrative discretion in furtherance of the Constitution's mandate. The classification of documents, including the exclusion of certain categories, apart from Aadhaar cards, which were directed to be included by our order of 8 September 2025, is based on intelligible criteria having a direct nexus with the objective of ensuring the integrity of the electoral roll. We are therefore unable to hold that the impugned documentation framework is arbitrary or violative of the statutory scheme. The Commission is empowered in the exercise of its constitutional mandate to undertake a limited inquiry into the citizenship for the purpose of satisfying itself as to eligibility for inclusion in the electoral roll. Such an inquiry does not amount to a determination of citizenship in the strict sense, and in any action taken pursuant thereto is confined to electoral consequences alone. The consequence of such a determination is correspondingly limited. It affects the individual's entitlement to be included in the electoral roll and thereby their right to participation in the electoral process. It does not, however, operate to divest the individual of claims of citizenship, nor does it foreclose a determination of that question by the competent authority under the Citizenship Act. In cases where the Commission is not satisfied that a person meets the statutory conditions for inclusion in the electoral roll, it would be incumbent upon the Commission to refer such an individual to the competent authority within the central government for adjudication in accordance with law. The Commission's determination, being confined to electoral purposes, cannot assume finality on the question of citizenship. Any deletion effected on this ground shall therefore remain subject to the outcome of such adjudication by the appropriate authority. Then we have issued a further direction regarding persons whose names have been deleted from the 2003 roll on account of the Commission being of the opinion that they are not citizens. The Commission is directed to refer such cases within 4 weeks to the competent authority under the Citizenship Act 1955 for adjudication of their citizenship claim. The competent authority shall take the necessary decision in accordance with law, preferably before the next Parliament, Assembly, local body election, whichever is earlier, after giving notice and an opportunity of hearing to the deleted individuals, if any. In the event the competent authority holds that such deleted individuals are citizens, they shall be included in the electoral roll. In addition thereto, all persons who are domiciled in Bihar and whose names have been erroneously deleted on the ground that they are absent, dead, shifted, or in duplication, may also assail the decision of the Commission by way of judicial review. These petitions are accordingly disposed of in above terms.
Grateful. We are grateful, Lords. Item number 1.
Item 2.
May I please? I'm appearing.
With my lord's permission, I humbly request to mention a matter, my lord. My lords, I have filed an urgency application.
Yes, please.
My lord, these are 3 bail applications. My lord had on the last occasion had directed my lords the DLSA to have my lord arranged lawyer for the victims. Victims were to be, my lords wanted to hear the victims.
What is the High Court has sent for communication? Reports have come from the High Court also, because earlier order were not communicated. That's why the legal civil authority, probably there was some delay on their part also. Now there is another report that's quite disturbing that has been sent by the former Director General of Police, who is appointed by this court to monitor about some latest incidents that have taken place, unfortunately. This affidavit says on 7th April, some incident, some two innocent children were killed. Then they, in retaliation, they attacked the CRPF post. Then CRPF opened fire, killing 3%. Then prohibitory order. There are some issues. I think
Now the trial is trial is in process, my lord, as far as this case is concerned. And there is
bail
one,
order remain intact.
my lord, there are two persons who are out, my lords, for which we have asked for, my lord's, cancellation of bail. One, the third application is where he is asking for bail. My lord, now the trial was earlier not progressing because, my lord, they were taking time for forcing the witnesses to be present in the court for
That's a wrong statement.
No, I'm just saying
That's a
something,
wrong
please
statement.
wait for some time. There, after some time, you can say. There are three problems that was happening. One was this is my instructions. Two, there is also a problem of, my lords, the translation from Kuki language, my lords, because the translator was not available. And both reports have been trying to put it on.
Conducting trials in Assam.
Trial is in Guwahati, my lords.
No.
So these are some problems. And my lord, there was applications where they said the victims were not ready to come to Guwahati. They insisted that for a better cross-examination. That is my instruction, my lords. Now, last occasion, my lords, the internet was down, so therefore, there is a Gemini order with me, my lords, where because of the internet was down and the entire state of Manipur, they could not join, my lords. One victim is already, my lord, examined. Two victims are yet to be examined. My lord, my only thing is there are about 30 witnesses. I have instructions to say that on because case is listed every 15 days, two witnesses, my lord, 6 months to 7 months, we should be able to conclude the trial. If, my lords, these two persons, my lords, it will, my lords, help in the proceeding because there is a certain amount of, because there are some witnesses, my lord, there will be.
May I please, your lordship?
Wait for a minute, please. Wait for.
Yes,
Where you
lordship.
are. No, but that may not be a good ground to cancel bail. Bail. There is no such allegation that.
There is no allegation, my lord. I must say it candidly. There is no allegation as of now. But, my lords, I only say.
Bail has been granted only because of the lapse. That is paragraph 18 and 19 of the.
My lord, that is where, my lords, I will say it is not completely, my lords, correct because two reasons. There was, my lord, the sanction was taken some time. There are other issues which took some time.
Mr. Deputy, we are not, frankly, we don't want to keep it pending in order to hear against the grant of bail. We are only keeping it pending for the larger issue because with a view to provide, to facilitate the victims. That's why we have issued certain direction to the state legal civil authority.
May I please,
to provide lawyers who can understand their language, who are local counsel and local dialect, they can talk to them. Similar problem not only with the victims or their families,
even the
problem with witnesses.
Witnesses also, my lord.
So we will probably for this limited purpose will continue to monitor. Rest of the issues will not interfere. Let us see that how the trials proceed because trials also need to be expedited in this matter.
Yes.
Lordship.
Can my lords only observe with this regard, my lords? I understand, man, and I'll bow to what my lords have said. except that, my lords, both the parties will cooperate with the trial, my lords, and will not delay it. We will also try, my lords.
Mr. Singh, you are the prosecutor.
My lord,
You have to ensure the confidence building measure in the victim.
we are doing that, my lords. We are doing that. Actually, my lords, a person goes,
Sending them back to jail really does not inure to any benefit until and unless there is a speedy conclusion to this trial and confidence
I'll bow, my
is
lords.
restored.
I'll bow, my lords. Let
not
me not
waste
press it
the-
further. Let me not press it further, but at least for the conclusion of trial, my lord, let both parties cooperate. And my lords can at least, my lord, then
Lordship, I just
a word of caution that both parties will, my lords, cooperate. They will accuse will cooperate.
Cooperation do you expect?
My
You
lord,
have to give that
unless
confidence
sometimes
to the victim. We have transferred the case to Assam. Earlier orders direction that the two state legal services authority would provide them lawyers for representation. So now you have a bridge through the legal representation they have.
my lord, there are 4 or 5 parties now. It is not only the prosecution, DLSA on both sides, the intermediaries who are trying.
Nodal person.
Once my lords have some kind of a, my lords, guidance with regard to that, my lord, then assistance getting, my lord, CBI getting assistance from all quarters is also as important for the purpose of conclusion of the trial.
So keen that the trials are concluded at the earliest because it's a question of victims and their families' faith in the system. That's more important. So therefore, the trials in any case will be expedited. But of course, as my brother says, that you have to create that environment, and they will also cooperate.
Yes.
Probably none of them is against.
A word from my lords will also help to do that also, my lords. I'm saying for all parties. That is, I'm insisting for all parties, my lords.
Lordship,
The logistical support for CBI is also as much important. A word thereafter, and if all parties will cooperate, we will, my lords, will then try. That is all I'm seeking.
Lordship, I appear for the victims, if I may just have a minute, Lordship. Lordship, just on 9th of May 2025, the same court, considering the bail of the same accused, noted the heinous nature of the allegations in detail, how they have been identified in TIPs, etc., and how the nature of offences were barbaric, and denied bail. And just on 8th September, not even a full 4 months later, they are released on bail by the same court, saying that there is delay of 4 months, Lordship, and given the nature of what Lordship's report also says, the circumstances there. Lordship, this delay didn't amount to a reason enough to overturn the view that the same honorable court had taken.
Also challenging the grant of bail.
Lordship, our SLP has not yet been filed, but I have instructions to file, and we're just awaiting. Lordship, please.
May not be really impressed by the way in which the High Court has granted bail. After all, it is a question of liberty. That is why it would require a very egregious situation coupled with a threat perception on the victims, which would persuade us to cancel it. At the same time, what we have indicated to Mr. Singh, our main concern is bringing home the truth through the judicial adjudicatory process. And for that, whatever support, confidence, and rehabilitative measures necessary, we are inclined to examine this petition from that perspective and ensure a clear conclusion on the finding of guilt or innocence of these accused. It becomes really no purpose to quibble over these interlocutory exercises of grant of bail or not. Finally, it matters is whether the prosecutor is able to conduct a fair trial and thereby a just conclusion with regard to guilt or innocence. The cooperation of the victim, and that is our main focus.
Lordship, just a propose what is falling from my Lordship, just 2 points. One, Lordship, 3 named accused in the FIR who are accused of very, very egregious acts of sexual violence and murder. One Loya, one Chinglen, and one in our town. Lordship have not yet been arrested. Lordship, and if Lordship remembers, I don't want to repeat the incident. Lordship remembers that these victims had taken refuge in a police vehicle, and the police man had taken the key and left them to the morgue. Lordship, no action taken against the police persons. It's not a,
These 2-3 names.
these three persons are still absconding, and so there is a threat perception. And Lordship, the policemen who are very easily identifiable, who had left the victims to the mob because they sought refuge in a police vehicle, and the policemen took the key and left them to the crowd along with the vehicle.
Mr. Pasha.
Lordship, no action is being taken. So those.
Mr. Pasha,
Lordship, please.
these persons have been declared as proclaimed offenders.
Lordship, please.
The trial has proceeded in respect of the persons who were there, and it is at the stage of recording of evidence.
Lordship, please.
In the event, the victim's evidence clearly disclosing larger conspiracy or involvement of other persons, including many in uniform, are placed on record, I think Mr. Singh's client are well equipped to get directions for their being arraigned as accused person. But if you, in that perspective, want us to pursue the absconding accused, then the most vital evidence, which will be the fulcrum for prosecution to convict individuals, will be delayed.
Delayed, and
which do you propose?
And that is why 299
then-
was taken.
Just on Lordship,
This
the
thing, the
non-arraigned.
confidence building measure we were talking of.
Yes, Manoj.
The victims remain traumatized.
Absolutely.
Right. So you have to give the guidance and the correct direction to the trial. That recording of the evidence in a clear, full disclosure of who are involved, who are not involved, whether they are charge sheeted or not, should be before the court. Then you can take your steps if necessary.
Precisely,
The
Manoj.
no investigation against the police personnel is also impacting the confidence of the victims' lordship. That is a lacuna in the investigation because there's been no investigation by the police personnel so far.
No, they are not party to
Go
the.
and depose.
They are not party to the case. They may be party to dereliction of their duty, but they can't be associated.
Whatever is Mr. Pasha's client's views, that is the deposition of the victim.
Yes, Manoj.
If that aspect has not been covered by the investigating agency, prosecuting agency, at this stage, it would be for the trial court to examine the evidence
May I please?
with regard to complicity in abetment, complicity in conspiracy, or as Mr. Singh indicates, maybe disappearance of evidence. Whatever is, that will be the trial court's call. Now, if you want the hand of the clock to be sent back, what would happen is the most important step would be postponed. That is the recording. Recording of versions in court.
Very well, Lordship.
Your Lordship, I beg to appear for the petitioner in item
In
2.2.
compliance
Lordship,
to-
my client is behind bars.
In
I'm
compliance
seeking
with
bail
this
on
order
merit,
dated
Your Lordship.
25th February 2026 and 24th March 2026. The High Court of Manipur has filed an status report, inter alia pointing out that registrars of both the High Courts, namely the Manipur High Court and Guwahati High Court, as well as members of secretaries of the state legal authorities, have established communication to facilitate the provision of legal aid to victims and their families. Semicolon, a virtual conference was held between them on 30th March 2026, followed by a physical meeting on 1st April 2026, in which the Advocate General of Manipur, Kumar, Registrar General Manipur High Court, and Member Secretary and other senior officers of the CBI and police, as well as Anti-Corruption Bureau, participated. They charted out a structured course of action for the appointment of legal aid counsel, from a supply of charge sheets, from addressing impediments such as travel, boarding, and lodging, etc. Next paragraph. On 6th April 2026, a virtual conference was held with their Assam counterparts to ensure that the legal aid counsel are appointed from both states for the victims and their families, and the necessary steps for such appointments have since been taken in 26 cases. Then main paragraph. Mr. Dattatreya Padsalgarkar former Director General of Police Maharashtra, who has been appointed by this court to monitor the ongoing investigations, has also filed his 13th status report. Inter alia, pointing out that the law and order situation is quite precarious, as new incidents of violence have taken place on and around 7th April 2026 and again on 18th April 2026. He has summed up, pointing out that due to bunds, torch rallies and sit-in protests, due to increase in bund, torch rallies and sit-in protests, the state police is stretched to its maximum. Next paragraph. CBI has also filed a status report to the effect that 20 charge sheets have been filed. Instead, there are 21 cases. There are 21 under trial cases. That is 13 before the special judge for CBI and NIA Guwahati, and 6 cases before the Chief Judicial Magistrate Kamrup Guwahati. Trials have commenced in 16 cases at various stages. Meanwhile, another complaint was received. No, don't say meanwhile. As regard to the complaint which the CBI had received on 22nd July 2024 regarding 2 missing students, the CBI has explained that despite 5 suspects have been arrested and the investigation is still ongoing, the bodies of the missing students have not been traced so far. Next paragraph. As regard to the status report filed by the SIT, it is pointed out that charge sheets have been filed in 297 cases against 414 accused. However, the trial has only commenced in 10 of those 297 cases only. Some meetings have taken place in recent times without the ongoing trial. And for the public prosecutor. Next paragraph. Another report number 45 and 46. May 26 and 25th May 2026 have been received on behalf of the 3-member committee headed by Justice Geeta Mittal, former Chief Justice of the Indian High Court. The said report inter alia provides as follows. Inter alia provides as follows. Next paragraph. We have briefly heard on additional social material on behalf of the CBI as well as on counsel for the respondents. The both sides have clearly suggested that the ongoing trials need to be expedited. Therefore, impress upon the CBI and all other stakeholders to provide especially the state legal authority, to provide legal aid counsel, provide legal aid counsel who are well conversant with the monetary or local language, stroke dialect, and who are able to speak, able to interact with the victims, stroke their family as well as the witnesses. witnesses. This will provide immense help in explorating the ongoing trial. It goes without saying that the both sides will also extend full cooperation in this regard. That if the status report the ongoing trials be along with details of the witness examined or yet or left to be examined the file before the next date of hearing. Post these matters on considered.
Your Lordship, Lord, may I file the counter affidavit in the reply?
Even counter affidavit can be also come.
Obliged. Your Lordship may take up 2.2 separately. My client was denied bail, Your Lordship. He was 18 years old when he was arrested. The only role ascribed to him was that he's in the mob and he recorded a video.
That will remain inside.
Your Lordship,
That was not the only role.
3 years.
That was his role was participation, and in addition to that, the video which brought this to the fore, he recorded that and circulated that widely.
Identified by all the victims also. Your Lordship,
We will see later on.
Lordship, just
for 3 years, the other co-accused are on bail. Whoever much heinous.
Lordship, just one. Lordship may consider, and so far as the other SLBs are concerned, Lordship, until the statements of the victims are recorded, Lordship consider let them be inside. And then Lordship can consider after the statements are recorded, because that's a typical order that Lordship passes, that once the statement of victims is recorded.
If there is any material information or allegation comes of their tinkering with evidence or influencing any witness, then you know the ground, then we will immediately take it. So long as they are within they understand the implications and they don't misuse it.
That the state and the trust.
Also, direct as an abundant precaution to the CBI as well as both the state governments.
May I please, Madam? I'm so grateful.
Compliance of the victims' protection. To ensure the compliance with victim protection scheme. So that's protection.
Victim and witness protection.
Schemes.
For the victims and their family. Their victim.
Family. Or other eyewitnesses or other vital witnesses.
I'm grateful, Lordship, extremely grateful.
All right.
Lordship.
May I? Grateful.
Lordship.
Will your Lordships consider the bail on the next date for 2.2, Your Lordship?
No, then item 3, I'm seeking for a passover, my lords. Mr. Sibyl is hearing in the matter, my lords. I'm being led by Mr. Sibyl, my lords. I'm seeking for a passover, my lords.
So we have it after vacation, my lord, then.
All right, item 4, next.
Wait.
Take a vacation paper.
Please, Lordships. 3 times when the Supreme Court has intervened, there was no recommendation. Concrete proposal has come as indicated by my lord in the last order, my lord. No concrete proposal has come for safeguarding the.
We will see, we will see.
Please, my lord.
Item 4.
Yes, my lord. My lord, I am confining my prayer only to the prayer number 1 in the writ petition, my lord. And lordship, may see at page 55, the rule, my lord, which was introduced.
Whatever suggestion, these are all highly technical things you have.
No, lord, no personal. I am not challenging any election.
No, it's
only
a
fair.
good thing.
What he is saying is,
In favor of it, it should be. But you please represent to the election commission, we will direct them because it's involved some technical aspect. They will have to see that how it can be ensured.
No, just to assist my learned friend, Lord. All the 3 times, not where your lordships not have put in place this VVPAT, and my lords improved upon its efficacy and transparency, my lord. Your lordships, my lord, took the initiative. So lordships, my lord, the election commission. So therefore, my lord, lordships may call upon the election commission here because we are not challenging any my lord's election, and we are only saying that the guidelines should be prospective. And my lord, what we are only asking, my lord, that when the VVPAT slip comes up, my lord, the time stamping should be done. So that, my lord, now there are a lot of allegations that, my lord, after 5 p.m., my lord, there is a sudden jump up of votes, etc. All that will be put to rest, my lord. So therefore, your lordships may kindly call, my lord, because representations and then decide.
We are doing the same purpose, we will just direct the commission.
Lord, in all,
Yes,
what
just
was
recently
only-
the previous.
Yes, my lord. What I was only suggesting is, my lord, I have put all the judgments on record, my lord. All the 3 times your lordships never pushed us back to the, my lord, election commission. Lordships may call upon them, my lords, and then ask for a reply, my lord, whether it can be workable or not. That's my respectful
Honorable
submission.
Lordship can treat this writ petition as a representation, will submit it to Lord.
But because you don't go to even commission, that the
Yes,
whole
Lord.
problem is
That's a
this.
shortcoming in this writ petition, therefore, Lord, we are making a
Everybody
request.
directly come to us, that is.
Yes, my Lord, that's a shortcoming, my Lord, therefore, my Lord, this impediment, Lord, Lordship may treat this writ petition as a representation, my Lord.
Instead, the petition under Article 52 of the Constitution has been filed purportedly in public interest. The petitioner claims himself to be a businessman and philanthropist, though no such details have been provided in the petition. That's why, be that as it may, the prayer instant petition revolves around the systemic enhancement of electoral transparency by mandating the time stamping of votes on voter verifiable paper audit trail in bracket VVP80 bracket close six. The petitioner contends that while Rule 49 capital M of the Conduct of Elections Rules 1961 specifically mandates that VVPAT slips display the candidate's serial number, comma, name and symbol, comma, it notably omits the exact time of the votes recording. This omission, comma, according to the petitioner, comma, creates a significant physical audit gap. As per that, the petitioner has thus argued that while addressing timing-based complaints such as late hour voting surges, comma, turnout revisions, or booth level discrepancies, comma, the physical paper trail itself remains silent on the exact time at which the vote was cast, rendering its evidentiary value weak. Rendering it evidentiary value weak. The petitioner has also cited on illustrative basis certain instances where large-scale last-minute voter turnout in 2024 in some of the states in the previous elections. That's why it is in this backdrop that the petitioner has sought a direction to the Election Commission of India to suitably modify the existing VVPAT related guidelines, manuals, instructions, and standard operating procedures by mandatorily incorporating a provision for printing the exact time of recording of each vote on the corresponding VVPAT slip. The petitioner also seeks a direction that the exact time stamping on VVPAT be implemented in a manner that preserves complete secrecy of voting and shall not include the voter's name, comma, EPIC number, comma, electoral roll number, comma, Form 17A serial number, or any other identifying particulars of the voter. The petitioner then seeks another direction to ensure that all VVPAT slips, including time-stamped VVPAT slips, once implemented, are preserved for a minimum period prescribed under Rule 94 of the Conduct of Election Rules 1961, and beyond such period where any complaint, request for verification, election petition, or any other court proceedings have been initiated. Next paragraph. Having heard mention constituted parties for the petitioner, Kumar. It seems that the issue raised by the petitioner is in furtherance of the electoral reform.
Integrity of the electoral.
Transparency. Fairness and transparency.
Transparency, accountability.
Election process. However, the prayers made by the petitioner, whether are feasible to give effect or not, is essentially a technical and policy issue, which is required to be considered a technical issue that falls within the domain of the Election Commission of India. Consequently, we dispose of this petition without expressing any opinion at this stage. With a direction to the registry to forward a copy of the entire paperwork to the Election Commission of India, which shall be treated as a representation on his behalf. Shall be treated as a presentation on behalf of the petitioner, and this is considered in accordance with law.
Not some timeline, my lord?
Not necessary for timeline to Election Commission. Otherwise, when there is a timeline, they should consider and reject it.
Not any order passed, my lord.
Sir,
Liberty to
always
come back.
liberty to come back.
Any the
Always
Election
there.
Commission order can always be challenged.
Lord, 3 days of refiling may be condoned. There's a 3 days of delay in refiling. That may be condoned.
That's it. Item 5.
If it may please, my lords. My lords, I do appreciate my predicament. The High Courts are burdened with pendency, particularly Allahabad High Court. But my lords, I'll be failing in my duties in not highlighting the grave hardship that I'm facing because of this pendency. I have a son who is 80% disabled. Please see, my lords. From July 22, my salary has not come. I'm earning only out of my two daughters I have, 18 and 27. Household is being run only by the tuitions.
Transferred post.
My lords, indeed.
Joined or transferred post?
My lords, I did join. I joined the Lakhimpur Kheri and I went on medical leave because, my lords, he's a grown-up son. I have to nurture, take him. All I'm seeking is, my lords.
Get your salary, how will you meet the medical expenses of your
So
son?
that's what I'm explained, my lords, that my daughter, one of the daughters.
Prioritize your importance.
My lords, one of the daughters
Working in a
who's doing tuition.
This is important or your employment is important.
My lords, if he's 80% disabled, my son.
We are going to request you as leader of the bar.
My lords.
You please survey in all the high courts.
My lords.
And submit a report what to do, because all high courts.
I quite see, my lords.
The pendency has gone high.
I quite see, my lords. But my lords, as I
fighting hard in prioritizing the matter.
My lords.
The problem is that if there is somebody, unfortunately, motor accident claim, he says, my priority because I have lost my brother or I am permanently disabled. I don't have any source of life. Where I go? Person who is in matrimonial dispute, they say matrimonial dispute has a lifetime.
Indeed.
We can't wait for becoming senior citizen.
Indeed.
Please tell them to get. There are persons in custody, incarcerating, they say our criminal appeals are pending. These are all competing claims and each claim has its own merit.
Indeed.
To say that this matter should be ignored is
that individual, their grief is most.
Our only problem is that now in this system, then we leave it to the Chief Justice of the High Court.
My lords, I've moved 6 early listing application. If I may propose, I may move one more if the Chief Justice of the Honorable High Court could consider that.
You file an application.
I moved 6 of them, my lords. They mentioned my application doesn't come. I have showed the case status.
That's why we are saying, please go and file an application.
If my lords may just put that, I would be deeply obliged. My lords, it's only because of the disability of my grown-up son. To take him anywhere, to give him shower, I don't have the means to keep a medical aid. That's the reason I request.
That nowadays, 4 or 5 matters are coming only for this purpose.
I quite see, my lords. In fact, I saw yesterday also, my lords had observed that. I understand my predicament. But as I said, my lords, the grave hardship. Just my application may be considered under the discretion of the Honorable Chief Justice of the High Court. That's all I seek, my lords.
Instant petition under Article 32 has been filed seeking a direction for early disposal of the petition filed by the petitioner, which is pending before Allahabad High Court. While we are not inclined to entertain a future petition from a migrant liberty to the petitioner's own application for the High Court, along with requisite medical report, so as to make out a case for out-of-turn hearing of his petition. We have no reason to doubt that such a prayer shall be sympathetically considered by the High Court.
Deeply obliged.
If you attach this order, it will take care of your.
Deeply grateful, my lords, for my lord's indulgence.
We have passed similar orders where we have requested the appellate tribunal to decide the matter at the end.
Much obliged, Your Honor.
Petitioners being aggrieved against deletion of their names from the electoral roll pursuant to SIR exercise in West Bengal,
Your Lordship,
filed their appeal before the.
Your Lordship, I just have one request to make. In the light of the today's judgment, kindly direct that no questions be raised on the citizenship of the petitioners and allow me the liberty to file if we are aggrieved again. So
Giving you liberty, you have already filed an appeal before the appellate tribunal.
yes, sir.
So we are requesting appellate tribunal.
We are giving directions for an early disposal.
We are requesting tribunal to decide your appeal at the end.
Much obliged, Your Honor.
Against which the petitioners have drafted appeals before the appellate tribunal constituted by this court, why don't they petition so? Yet the appeals are still pending that the petitions have brought this court. We have hardly unconstituted. Keeping in view the facts and circumstances, the petition disposed of with a request to the appellate tribunal to decide the pending appeals at the earliest and preferably with the court.
Lordship, the petitioner has the disability, locomotor disability, myopathy. The High Court has rejected the my lord, the petition was pending before the High Court. There is no, due to dependency, there is no apathy on the part of the
No
petitioner.
interim order, how can we help you?
My lord,
There's no interim order. How can
Lordship, but the posts are at
All
present
filled up.
there.
All filled up.
But the current posts are there.
Current posts are to be for a current application.
My lord, then if he has been illegally denied the opportunity, then he has a right. There are posts every time, my lord. He has repeatedly, unfortunately, due to the huge
Following,
pendency.
but you have not even annexed the GO, 2011 GO. The
Lordship.
entire petition doesn't contain the 2011 GO.
My lord, we have challenged in our petition.
No, recently you have not annexed it.
My lord, but it has been mentioned in the counter, my lord.
That is where he will have a right to. Keep this issue open, that you may be entitled in a fresh or any other selection exercise to seek reservation under the PWD Act as per law. So that issue we will keep open, so that this judgment does not stand in the way.
My lord, may kindly see, but if he was eligible at that time, my lord, in the number of judgments, if
You have not annexed the GO here, the entire exercise is over.
my lord,
Why we will
my lord,
allow
may
that?
kindly see page 44 of their counter. They have mentioned,
Counter only refers to it. We have seen page 46.
lordship.
There is only a reference of that GO.
Yes, my lord, and this is page 44. It is also page.
Point is that did you rely upon the 2011 this office memorandum?
State has, the High Court has relied on, my lord, on this memorandum, which does not specify 1 lakh.
So why don't you challenge that memorandum being contrary to the statute? Parliamentary state.
That has been challenged in the writ petition, my lord. We have challenged that writ, notification.
A prayer to quest, to set aside that office member.
कहाँ challenge किया है?
My lord, may kindly say, direct the direction nature of certiorari, quashing the notification issued by the state. Kindly see page 39, my lord.
Notification will be, are you talking of selection notification?
No, my lord, issued by the state, notification dated 30th January 2011. My lord, page 39, lordship. This is the prayer.
So prayer contained in.
Right.
In your prayer number 1I, made by the petition before the High Court, and the writ petition, that notice be issued in terminable solicitor.
Obliged.
Only thing is that we need to remand the writ petition so that High Court is requested to decide on marriage.
Obliged, my lord.
Find the geo.
Lordship, lordship.
Annexed to this.
Lordship, lordship. Obliged, my lord.
Item 8.
My lord, this is for the constitution of the Third National Pay Commission for Judicial Officers. And the first order your lordship passed was on page 106. 206.
Mr. Ranjana Desai is already looking. Mr. Ranjana Desai is already looking into this aspect. And
No, earlier your lordship had passed a judicial order on page 206.
judicial order will be required only when they don't act upon. They have already acted upon. And I can share with you, Mr. Ranjana Desai is actively considering entire aspect. He has in fact gathered information from.
I understand that, my lord. May I just read few pages why this order is required? Your lordship may come to page 206. This is also by the judicial officers, and kindly come to page 211.
Yes.
211. In the circumstances, in the middle, we deem it appropriate to appoint a commission to be headed by Justice P.V. Reddy, a former judge of the High Court, and so. To be a member, the commission would be assisted by a secretary who would be chosen by the commission. After this order was passed, the commission submitted a report in 2020, and kindly come to page 898 of that report. In the second volume.
Please come to page 207.
Yes, madam. I will.
The last paragraph. By an order dated 8 March 2017, this court reported that for adjudicating the various questions raised by the petitioner in the instant writ petition, certain data is required to be collected, and for that purpose, a body competent to collect is required to be constituted.
Same body.
Because there was no commission, pay commission.
No, the same body was requested to collect the data, my lord. This commission was requested to collect the data.
No, was there any pay commission headed by a former judge of this court?
My lord?
Was there any other commission headed by a former?
Justice Shetty Commission, first.
No, that is the earlier one.
This is the second.
This was the second one, understandable.
Yes. Now we are praying for the third one to be constituted by a lordship.
Because already a commission headed by a former judge of this court has been constituted. That commission is already considered.
That's why I said, my lord, kindly come to page 898. 898 in the second one. 898. The report submitted by the second pay commission. Is the report from page 898.
That's it.
And kindly come to page 913 of that report. 913, running page. What is the recommendation made? And this report has been accepted by your Lordship's court.
Every day we deal with it and we have been ensuring that this is implemented.
Yes.
We are only on the point of constitution of the next pay commission. Suppose there is an inaction on the part of the executive. If they don't do it, you are absolutely right. On judicial side, we have intervened in the past and we will have to intervene.
So this report recommends that once the central government appoints the commission, there should be a separate commission for the judicial officers, and it must be put in place and made operating within 1 year from the appointment of that commission. That is why I just want to read it, my lord. Para 5 on page 913. 5.1. A national judicial pay commission shall be constituted by Union of India after 1 year after the central pay commission is constituted. That means the next NJPC has to be constituted by April 2025. And they are given details why it is to be done in 5.2.
Commission is already working on it. Commission is headed by a former judge of this court. Today, asking for a new commission means what?
No, your Lordship's court has always said, right from 1994, for judicial officers, there has to be a separate commission. And in fact, in 2000...
Because a separate commission was because no mandate was given to the existing commission and not necessarily the pay commission were headed by former judges. Therefore, a separate commission.
I have placed on record the judgment of Justice Kripal's bench, 3-judge bench, CJI then, which said that the reference to the judicial officers' pay structure in the central government has to be deleted. And there has to be a separate commission for judicial officers. And Justice Desai is heading the pay commission only for the central government.
The other employees can have a problem to say that why a former Supreme Court judge is examining their pay structure. Judicial officers can't have an objection that a former judge is examining.
That is why 5.2, the commission has explained. 5.2 on page 914, the commission has explained why this is necessary. And waiting period of 1 year.
Please collect your information and you find out, then we will examine it. First is matter in July.
The Lordships will keep in June, July sometime? July will...
Already lot of work has been done. They should not ask for reversing everything.
My lord, I have no doubt about it. But your Lordship's court always has said the judicial officers pay commission pay will be decided by a body appointed by your Lordships.
It was because whenever there was no mandate that the pay commission constituted will be comprising a judicial representative of the judiciary, and therefore it was necessitated that a former judge of this court should examine. If that condition has been complied with voluntarily without the judicial intervention, where is the necessity for us?
My lord, that explanation also has been given by your Lordship's court and said that if independence of judiciary has to be maintained, the pay structure of the judicial officers should be separately decided.
It has to be exactly.
And not by the Central Pay Commission.
It's not the Central Pay Commission. It's a question of that who is heading the commission. This is only for the commission. Pay scales will have to be granted by the government. If they don't implement, we will direct them to be implemented. The question is only today that who should examine our claim. It should be left to the executive or it should be examined by an independent body.
Your Lordship's order is on the second part, by an independent commission constituted by your Lordship's court. We'll come back.
Ask a judicial officer saying something, please don't let's not react to that.
We'll come back in July next month.
Item 9 and 15.
Yes, my lords. My lords, these matters pertains to the bank builder and builder agreement, my lord, with respect to the Himanshu Singh matters, my lord, where the bank had disbursed 90% of the loan amount, my lord. Immediately, the flat was...
No, but you are also look at 2019 DRT order now you are challenging. What have you done against that?
Because for the challenging the order in DRAT, I have to pay 50%, my lord. So
therefore you don't challenge the order of the DRT anymore.
because it was passed in Lucknow.
Don't misuse it now.
No, I'm not misusing it, and because they disbursed 90% of the amount. The building is not completed, my lord. Till today, I have not got the possession.
Then you should have come before us on time. 2019 DRT order, you have accepted, you were sitting at home. Now, because subvention matter we are examining, you are challenging the 19 order. Look at the danger of the opening this kind of.
Lord, but there was agreement, so I know, my lord, that has been fault on our part. We should have gone there, but since, my lord, this question of law.
Challenge that order.
Yes, my lord, but they disbursed 95% of the amount. I know, my lord, we should have challenged that order.
Are you party before NCLT or NCLAT?
We have filed the claim, my lord. We have filed.
Then please pursue that claim.
My lord, the claim is filed. The claim will go to the bank only, my lord, because the amount is going to the bank only. Because we have just filed it, the claim is admitted. So
challenge that order.
My lord, but recovery proceeding is going in, my lord. Even so-called arrest is being issued against me in item 50, my lord. So at least till that is pending here, my lord. Till that may be stayed. I'm not asking for the stay of or the proceedings, my lord. The recovery may be not be proceeded against me till it is pending here, my lord. So that is what my limited request here, my lords. Maybe tagged, maybe examined, and then, my lord.
We don't challenge anywhere. Suddenly in 2026 and you come and on a fine morning you decide to challenge of 2019 order.
Because, my lord, I have to pay 50 lakh rupees. I did not have for challenging the order. Also, I had to pay, my lord. But there is no fault of me because there was a tripartite agreement. There was a mode of disbursement, adverse circulars, my lord, that has been defied by the builder bank, my lord. So that is why, my lord, where do I go, my lord? Because the order has been passed against me. So I'm just requesting it to be tagged, my lord, and till it is pending, the no initiation of recovery, my lord.
So simply urgent propose it.
Let stay be recovery
No,
be.
no question.
Lord, because they have passed this
application there and then we'll see.
Lord, we have already filed. Lord, just a moment. In item 50, Lord, we have sent it to the recovery officer. It is pending here.
Now decide this matter. Otherwise, this will create.
Lord, in item 50, just for a moment, Lord, see, we have told to the
item 56 दिखाना क्या?
ये notice दिया है.
In item 50, my lord, just for a moment, we have also said to recovery officers that it is pending here. Then also. And in item 50, my lord, I am the guarantor. My lord, in item 50, I am the guarantor. I'm not even the borrower, my lord. They have passed, so that is the difficulty, my lords. Just for the pendency here only till stay that recovery.
Sorry, young man, don't file this kind of claim.
No, my lord, there are other matters also filed, my lord. Grateful, my lords. So these are tagged, my lords. Grateful.
Item 10.
Item 10 is a very important matter, my lord, dealing with these homeowners of projects promoters who have siphoned out large amounts of money, my lord.
There is not in that group where we have directed CBI.
No, this is not in that group. In that CBI has been ordered? No. I don't think CBI has been ordered in this particular.
No. In subvention matter,
yes,
which we have referred, there are about 17 or 18 builders different. We don't recollect whether he.
This is not in that. This is not in that. Firstly, my lord, of course, it needs a CBI investigation. Secondly, more important, this is probably the largest of those projects. 25,000 homeowners, 14,559 crores collected from those homeowners. And my lord, now though, of course, the company has gone into bankruptcy and there has been NCLT, NCLAT, etc. But the issue is, the ED, which has been investigating the matter, has said that ED investigation revealed that out of approximately 14,559 crores collected by JAL and JIL from more than 25,000 homeowners, substantial amounts were diverted for non-construction purposes and siphoned off to related group entities, including JPC.
They have done like this.
Yes.
Most of them.
Yes. So therefore, now, my lord, there are some larger issues which arise here. One is, your lordship has been saying that this is happening in project after project, very large number of projects that this has happened. where funds have been collected from homeowners, funds have been diverted, companies have gone into bankruptcy, etc. Now, the problem is, my lord, the homeowners are left in a situation where the diverted funds are never identified or are not identified in time and not brought back in time, because these funds have been diverted to their own other companies and other assets, etc. Secondly, my lord, these people, what they do is that the lands, etc., are transferred to other group companies and so on. So therefore, my lord, those are larger issues which need to be examined. One is, if your lordship just sees the prayers that we have asked for, there are a number of prayers. If your lordship first sees the prayers.
Only the RBI to conduct a comprehensive audit of all banks' exposure.
Because this is happening in project, this is the PIL nature prayer. Then second, my lord, to complete, ED to complete the investigation, recover the money, etc. Because they have so far attached only 400 crores worth of assets. The assets involved are, my lord, more than 14,000 crores. Then, my lord, prayer 6, that is pass interim directions to the Directorate of Enforcement to complete its investigation, and if if proceeds of crime are found to be embedded in the underlying land or development rights, to issue provisional attachment orders in respect thereof, so as to protect existing and prospective home buyers in those projects from the consequences of belated attachment and to prevent dissipation of the assets. Because what has been happening is that these assets are usually never recovered. Investigations happen. The assets have been found to have been diverted to related companies. The recovery doesn't happen. It doesn't inure to the benefit of the homeowners or.
Has been registered by ED?
Yes, they have.
ECIR has been registered.
ECIR has been registered. But there is no CBI investigation in this matter.
You are not asking for CBI investigation.
No, we have not asked, but in fact, my lord, there should be, because the investigations.
In other cases, why we are saying, because in all other 17, 18 developers.
Yes, I know.
There the CBI, the economic offence wing, we have directed.
What will happen now? ECIR? Raju, Mr. Raju.
Date in July.
There is another matter arising out of that same JP group, which has come up before your lordship in a different way, where, my lord, the High Court had ordered the Yamuna Expressway Authority to take over that land. The land was given to this JP group by the Yamuna Expressway Authority. That order has come before your lordship, which your lordship is examining. But that is not directly related to the issues
that will be a very small part of
Yes. This is a much larger issue, and, my lord, involves great public interest. In fact, my lord, one of the things that we have asked for is that the Reserve Bank should do an audit, because this is happening across the board, and so many banks are losing money because of these kind of projects. And therefore, Reserve Bank needs to do an audit of the banks which have lent money for these kind of projects, and where the banks are also losing money, because ultimately what happens is, when that NCLT proceedings conclude, the kitty left is very small, and therefore that has to be then distributed between the banks, the homeowners, etc. And even in this case, my lord, the order is that probably the buyer has to now complete the project in the next 2 years. So one of the things that we are asking is that it should be monitored, that so as to ensure that the construction is completed within the next 2 years and the flats are handed over. It's already been delayed by more than 12 years.
But is it a kind of NCLT proposal that has been in NCLT?
Yes. NCLT has said.
Insolvency proceedings.
Yes, in NCLT, for homeowners, the prescription was that either they will the new buyer will complete the construction of these flats in 2 years' time, or alternately, they can get a refund of their original money. Though earlier a settlement had been arrived at between the home buyers in the consumer forum and this JP Industries saying that refund would be with 12% interest. But now, under the NCLT proposal, if we want refund, we will get the original money which we paid more than 12 years ago. And Lord, there is nothing about the, we don't get any interest on that money. 12 years ago, my Lord, what we invested was, today if we want to buy a similar flat, it will cost us 3 times as much.
It's a very complex kind of issue.
Yes, it is a complex issue. I agree, my lord. It's a very complex issue. But there are issues involving how the banks lend for these projects. There are issues involving what kind of securities that they take for the projects. Those are general public interest issues. And then, my lord, there are issues involving whether the diverted funds, the siphoned out funds, are recovered for the purpose of the home buyers and the
other issue that probably yesterday only a sample came before us, that will take it as a sample only. The issue is that they are valuers and the market, their companies, incorporated entities. When a builder wants to take loan, they will say, this is the property I will mortgage. They will assess, they will say this property is of 500 crore. So the loan will be sanctioned 400 crore, 450, saying that we have secured everything. When question of selling that property comes, they will say the market value is 50 crore.
Same thing, different thing.
That is another
different thing. No, another fraud is they'll say, ki, look, our shares of this company are valued at 5,000 crores. Therefore, give us 2,000 crores loan. And those share valuation is hiked up by insider trading, etc.
That also there.
That also has happened.
But in the case of at least real estate assessment, nobody is going to accept that in Indian market it will go down from 500 to 50 crore to 10 crore. But unfortunately,
these are, my lord, issues which your lordship should examine, because this is happening across the board. So that's why I'm saying there are some.
We'll see the other challenge will come, that whether the RBI has an investigative mechanism or not.
They do have something, because they do inspection of the banks and so on. They do have something. They come out with inspection reports of the banks. So therefore, it's not that they don't have.
Under the new Companies Act, the SFIO, which does the investigation.
Actually, my lord, these are matters
for a regulatory body as to whether the banks are complying with the directions and the financial policy.
RERA was supposed to be one such regulatory body. Unfortunately, RERA, there are lots of problems with RERA also.
Mr. Bhushan, otherwise, because there you are asking for RBI, etc.
Yes.
We are issuing separate notice. Otherwise, in that order where we have given to CBI and the Economic Offence Wing,
yes,
one of this JP infrastructure is also there. But it may be that only there one project.
Because these are many projects.
Six clusters.
6 clusters, my lord, are involved. 25,000 flats.
Some orchards project in Noida, where probably ED has registered RC number 219.
Yes, ED has registered.
CBI has registered RC number 219 of 25. Is also there.
ED has registered in this case, but they are saying that there are multiple FIRs of EOW Delhi and UP Police. And it is on the basis of EOW Delhi and UP Police that ED has registered the CCI.
Let us see what they will say in response.
Yes, yes. For the time being, your lordship may ask the ED to submit a status report about their investigation, because if your lordship just sees their press release, which is at page 873, volume 3, it says, this is a press release dated 7th January 2026. It says that Director of Enforcement has provisionally attached immovable assets having current market value of 400 crores, belonging to JP Industries, etc. And then they say ED investigation revealed that out of 14,599 crores taken from 25,000 homeowners, substantial amounts were diverted to non-construction purposes and siphoned off to related group entities, including JP Seva Sansthan, JP Healthcare, JP Sports International, etc. It has also been revealed during the investigation that Manoj Gaur is the managing trustee of JP Seva Sansthan, which received substantial part of the diverted funds, etc. So they have said something in this press release in January. They must update the status report as to what they have done in the last 5 months, in this 6 months in this investigation.
We are required to issue different kind of directions to 2-3 agencies. So better we issue notice for the opening and let them come, because ED will also respond. And then we'll see that how they coordinate between RBI and some kind of coordinated mechanism will have to be created.
Yes. For investigation and for recovery of money. Time of life.
Item 11.
Yes, my lords. My lords, petitioner is about 68 years old. He is suffering from kidney problem, my lords.
Will dispute, property dispute, one kind of we can't issue this kind of direction.
My lords, kindly allow me to withdraw, my lords.
All right.
Withdraw with liberty to approach High Court.
Also, for the petitioner seeks and permitted to withdraw this petition as he wants to know an appropriate application before the High Court.
All right.
Already, sir.
All right.
May please, my lord, first I take leave of the court to argue in person. To argue in person, my lord. My lord,
Higher court or anywhere, why do you have?
let me explain, my lord.
You can appear before us.
Yes.
Why don't you practice in Supreme Court and appear before us every day?
Yes, my lord, but it's my right. I have so hundreds, if 90 out of 100 advocates who are senior here, they are practicing in NCLT.
Have you ever heard that a High Court retired judge will go and district court conduct the trial?
No.
Have you seen ever? It's the same principle, keeping your stature. You are a member of you are a judicial member, you have remained judicial member of the highest tribunal, National Company Law Appellate Tribunal.
Yeah.
So it is to maintain the dignity and status and stature of your office. They say you will not practice in the lower tribunal.
My lord, I have another reasoning. What article, delegated legislation cannot surpass the constitutional
for this condition.
My lord, give me 5 minutes. If I convince you, lordship, what constitutional 7th constitutional amendment was brought only to be. There was complete prohibition on the practice of the retired honorable judges. That regime was changed and practice was allowed in other high courts. Where sitting high court judge, or retired high court judge, holding the constitutional appointment, can practice if he is posted in Delhi, he can practice in Allahabad. He can practice it.
That's right, because he can't practice it. He can't practice in the district court. And there are no other appellate tribunal where you have been debarred.
No, yes, my lord, there is. I have been posted in Delhi and there is Chennai bench. I have never been posted there, but I am debarred from there. My lord, any constitutional, any restriction which can be imposed.
There is a difference between High Court and benches of NCLT.
Yeah.
NCLT is one judicial authority. It may have benches.
Yes, my lord.
May have 4 benches.
Yes, my lord.
The retired High Court judge cannot say that since I have posted in bench A, I will practice in bench B.
Yes.
You can practice in other high courts. Similarly, in your case, you are a judicial member of NCLAT, not a judicial member of a bench. Bench is only an administrative convenience where the chairman will ask you to discharge judicial duty in a particular bench. So the comparison you are making is actually not correct. The High Court judge would not be permitted to practice in any bench of that high court, but would be permitted to practice in other high courts. Like you can practice in the high courts,
Yes.
all the high courts, 25 high courts in India, before the Supreme Court, but you cannot practice before the NCLAT or NCLTs. That's it. It is not a prohibition, it's a regulation, keeping in mind the high office that you have held and the dignity of the office.
My lord,
It's a very reasonable restriction on your right to practice or carry on profession.
question is, my lord, it's my right. Another thing, the reasonable restriction, only I have a right,
Very reasonable, sir.
My lord,
Never
my lord,
see it's
there-
unreasonable.
if a high court, my lord, reasonable restriction, the constitution has set a parameter. And by bringing seventh constitutional amendment, a parameter has been set. That cannot be breached, my lord. That is the highest parameter.
Anything else?
My lord, Rule 7 was earlier set, held unconstitutional, and Andhra Pradesh High Court, it remains suspended for 17 years. After that, Bombay High Court, Honorable Justice Sawant, when he was in Bombay High Court, he set aside the order that is unconstitutional. Again, the same rule was again implemented in 2013 with only one limitation, it will apply to the area where the High Court was last put.
That is the regulation. Otherwise, it was becoming a complete prohibition. Here is a restriction that if district judge, he in that jurisdiction of the High Court will not practice.
My lord, it is a.
You are a member of a supranational tribunal.
Yeah.
Having jurisdiction throughout India.
My
How
lord,
can you expect yourself to be equated with the?
my lord, one thing please consider. It is by banning my practice in NCLT and NCLAT.
We will welcome you to address us in the Supreme Court, but not for NCLAT.
If you are banning my practice, what will be the effect of this? Please consider.
Effect we have already articulated. The majesty and the dignity of the office that you have held.
It is a domain of law, my lord. Up to first appellate stage, entire
independence and fairness and transparency in judiciary.
My lord, one thing more. If a income tax, another thing I would like to
consider the conflict of interest and the perception to a lay litigant.
My lord,
till today, you were a member of a tribunal, and let us say you were assigned bench X. Your colleague in bench Y, upon retirement, you start practicing before him. What would be the perception amongst an ordinary litigant? The independence of judiciary is perhaps.
Yes, my lord, it should be. That cooling off period could have been alternate. What is there, my lord? This constitution bench of this honorable court in modern dental case has said that by when you are imposing restriction, it will not be seen to whom it is to be imposed. See, my lord, only 4 lines I would like to read in modern, that judgment is per curiam, and 4 lines I would like, with permission of this honorable court, only 4 lines I will read, my lord. Reasonableness of a restriction has to be determined in an objective manner and from the standpoint of the
We have understood that. Now you want to press, we dismiss it, or you would like to withdraw it, Mr. Singh?
Alternative, permit me to alternate, I will, because the forum, alternatively, elsewhere I will try, my lord, permit me to withdraw with the liberty to raise the same.
Sir, you have heard the petition person. During the course of hearing, the petitioner seeks and permitted to withdraw this statement.
Highly obliged, my lord.
Item 13 and 25.
No, 27, there is some letter circulated. No, today I'm not appearing in 27. 25 is not connected.
That's not connected to this.
25.
That's not connected to this.
The office report shows that they are similar point in.
No.
Is pending, if my friend doesn't mind. Or the office report shows not that similar matter is pending.
No.
Nothing to do with it.
If my friend.
In his petition, he cites that there is a similar matter. It's not similar at all.
There is no grave urgency, we will take it in July.
Very, as your lords.
Lordship, take it in July.
Otherwise, my lord, a person who is one of the biggest smugglers in India is after customs officers.
Similar,
That
is what my friend is trying to say. I will show, my lord, what the local order says and what the other people are saying about the very person, my lord. So therefore, my friend
CBI
should
conducts an investigation.
CBI.
Directorate of Vigilance conducts an investigation, finds that I am not involved in that. And he is a person who is agreed by the order of the High Court.
How he cleared my shipments and how thereafter he turned around and why did he turn around?
I did not clear it.
All that, Lord, I will show you.
We will hear both.
No problem.
It's honor among thieves. There should be honor among thieves.
There's a clear division.
But I am not, but this officer is not a thief.
No.
Now you have given him a clean sheet.
Let the Lokpal decide. What is shying away?
It's up to the.
Whether it's a case of crime or negligence is a matter to be seen. But the fact remained under his nose, some clearances were made which are completely dubious.
Correct. And those other officers are saying that he is
I'm a revenue intelligence officer. When I have nothing to do with this, the RPs in Kolkata, my lord, are still hauled in.
We are not expressing any
Very
opinion on your case.
Very
much obliged.
Obliged.
Item 14.
May it please your lordship. Lordship, this is a petition. This is a petition, your lordship, whereby despite there being guidelines to keep 1 meter of the base of the trees concrete free,
Everything has been given by the High Court, by NGT. What more do you expect?
lordship, the guidelines.
You are aggrieved because NGT did not give a notice. You are not aggrieved that your relief has been granted without a notice.
No, lordship.
The other party we can understand will come to us saying that, look here, so many sweeping directions have been issued. You are not even heard.
Lordship, the grievance is that this order is a reiteration of a guidelines which have been there for 10 years.
Sir,
Yes.
if this order which you say it is the duty of NGT to monitor and implement.
Yes, sir.
If you feel there are breaches, you take out fresh applications before the NGT. That there is a breach, you have given this order, this guideline, please see this place, this is not being followed, that place, this is not being followed. We can't direct the NGT to go into and fishing and roving inquiry everywhere. Wherever, please find out wherever there is a violation.
Or wait for the other parties to come, you will have to defend on this side.
I bow down to that, lordship. I just
This
wish to make one small
If you
submission.
feel there is a breach, take it up before the NGT.
Just allow me, lordship, just one submission. The guidelines have been there. There is no compliance. My petition was to seek compliance.
Execution.
Lordship, I also prayed for immediate restoration of those trees. That prayer has not been considered.
Go and ask the NGT to implement its order.
Lordship, my petition was in the nature of execution only in the first place.
Liberty to do that. We are giving you liberty to do that.
Lordship, just one submission. That my petition in essence was seeking accountability as well as immediate restoration. While they have passed
that you are targeting someone who is not hit by this order.
No, lordship, there is none of the officers have been mentioned in the petition. It is on the basis of a news article. Lordship,
Now tell us please, you want to go there or what?
Lordship, I just pray that if some observations can be made vis-a-vis
There is comprehensive order in your favor.
some time-bound manner compliance of the order may
Go
be.
there first, you don't go with the.
It has not been implemented till date, your lordship. It has been more than a month and till date those trees are suffering, your lordship.
All right, it's your choice now. You tell us right on. We see no ground to interfere with the.
Lordship will withdraw with liberty to seek implementation.
Appellant seeks and permitted to withdraw this appeal with liberty to approach the NGT for giving effect to the directive already.
Okay.
Item 15, Seema Singh.
May it please your lordships.
My lords, the point here is that the pattern and syllabus. My lords,
Already dismissed.
I know that. I know. I have a point. If your lordships could just hear me out. Otherwise, my lords, the pattern and syllabus as prescribed by the selection committee shall be part of the notice mentioned in sub rule 1. So, my lords, the original notice.
14/3/2024 is a new notification after the amendment of the rules.
Correct, my lords.
Then,
my lords, this cannot.
Are you applying for earlier 4/3/2024 notification, or you are applying in response to 14/3/2024?
My submission is, my lords, that this
That's
could not
your
have
answer,
happened.
sir. You can.
My submission is, and my lords, High Court simply says that the other petition has been
Correct,
dismissed.
because the High Court has too many important cases than your case to reiterate all reasons.
My lords, the High Court says since I participated, High Court says since you participated, that's how you cannot challenge. Your lordships have said, my lords, in that Mita Sai's case, merely
not going on the reasons. The notification we have seen 14/3 is an independent notification of 4/3. So your case that it violates Rule 7 does not come on the facts of the case.
My lords, my point was that you can't change the rules midway, my lords, because what has happened is the original.
Earlier,
That was the precise argument.
वही बोल रहे थे.
Some of these we couldn't be convinced that they used the fact that SLP against in the Manisha Saxena's matter, SLP civil number 5141 of 2026. Manisha Saxena was suspected PP already stand is 193/2026. And we see no ground to entertain especially.
My lords, the cause of action started with his own.
Delhi High Court. Why are you coming here?
He filed in Delhi High Court to begin with. But what has happened here, the jurisdiction of UP also involves when. So all the three lords.
All high courts are at
That means, lords,
They have given stay. If we would have understood that there was a divergence of opinion, intervention of the Supreme Court was necessary. If all the high courts are agreeing with you,
High courts.
please, yes, so two high courts, and the third is the Delhi.
Allow me to make the submission, lords. Two high courts have taken that view, but the fact is when we have prepared the chart, it's almost all bar councils who are charging. In his case, he would have to pay to the Bar Council of Delhi as a transferred Bar Council, then the BCI for the processing the application, or then the Bar Council of UP as a transferee. And kindly for a moment see the chart which we have prepared, which is, it's not involving one High Court or one Bar Council, my lords. Kindly see for a moment the chart. Page H of the synopsis, my lords.
Madam,
and it is on the face of section 18.
Of a high court is not territorially restricted. It is based on cause of action, and any authority, even beyond its territorial jurisdiction, including Bar Council of India, is bound by its.
My lords have been intervening in such cases where this kind, lords, violation is of writ large. Can you see for a moment page 8, minutes?
What happened is that petitioner is a practicing advocate.
Practicing advocate.
He has himself has filed writ petition in Delhi High Court.
I'm sorry, my lords.
He himself has filed writ petition in Delhi High Court. Right?
He did file.
Today, if we entertain here also, it's not appropriate. Other litigants will also come and say, we should also be allowed to have parallel litigation.
The occasion to come here is only for one reason. When he filed before Delhi High Court, by that time, he was not asked to pay by the Bar Council of UP also. It's only when so kindly see for a moment, Lord's page H. Just for a moment, kindly see page H of the synopsis.
Include Bar Council UP in that very petition, because your cause of action, principal cause of action, you can include there also, and we will request the Delhi High Court to expedite the hearing.
For a moment, kindly see page H, writ large, kindly see page H for a moment only.
Supreme Court should interfere, entertain is not necessary.
Lord, we have no option but to bow down before my lords. Kindly before that, kindly see page H. I'm just beseeching this honorable court, just see it's writ large on face of, and kindly I'll just show the rules, and then I'll not leave it to this honorable court. Kindly see section 8 for a moment, 18.
Every day we are entertaining, that does not mean that every action against BCI should come in Supreme Court only.
But that's something on face of the act. Kindly see for a moment section
Therefore,
18 and page H.
give the breathing time to the High Court. You yourself have gone. Please, we will request the High Court to decide at the earliest.
Then my lords would be giving me liberty to implead Bar Council of UP so that I'll just amend that challenge in place of filing 2 writ petitions in 2 different high courts.
In view of the fact that the writ petition filed by the petitioner, that the writ petition seal number 1854/2025 filed by the petitioner on the same cause of action is pending before the Delhi High Court. We are not inclined to entertain this the instant writ petition. The petitioner may pursue the pending writ petition in which he may, if so advised, may implead the other state bar council against whom he is said to have got a fresh cause of action. We also request the Delhi High Court to expedite the final disposal of the above.
Because they are not even proceeding further, my lords. So the Bar Council of India is not even filing their reply despite passing of more than 6 months or more so.
Yes.
So if my
Delhi
lords
High
will kindly
Court,
fix the
Madam,
time frame. My lords, now would my lords kindly see page H for a moment, my lords. I was beseeching to see that for a Kerala, if somebody seeks a transfer from Delhi to Kerala, 25,000.
18,000.
25,000 total, my lords. I have paid 18. And my lords, it's across the country, my lords. They're charging like that while the section says without payment of fee. And Bar Council of India has framed rules. So Bar Council's rest process, Bar Councils can't do anything because Bar Council of India is framing the rules. And kindly also appreciate, we are coming again and again against the Bar Council of India. Then something serious to be seen against Bar Council of India. Why so many discrepancies are being pointed out?
Madam Shobha.
And on face of the section, my lords.
We could only provide a fair and free platform to the legal fraternity to elect whomsoever they want. So we have got conducted the election. Now let us see what is their choice.
Lords are dealing with all those petitions. And now the challenges to the election process also.
They are concluding by saying, let us wait for their choice.
Lord, even for that co-option, my lord, the hearing on 29th, we would be troubling my lord again.
Item 17.
My lord, I am on the behalf of petitioner and my petition for the expedite hearing.
You must have seen earlier orders also. Today itself there are 4 or 5 matters. Well, same order could be Delhi. Allahabad.
My lord, then liberty to approach. Liberty to approach on river.
Liberty. Second Shobha, yes, madam.
My lord, my humble submission is every day, my lord, the thousands of lawyers, litigants, and the prisoners, my lord, they appear the courts, my lord, to attend the day-to-day hearing, my lord. If my lord may see the every court's cause list, my lord, 70% of matters are listed for the miscellaneous purposes, my lord. The entire nation is.
We are 100% with you on this issue. But the point is that it cannot be enforced through a judicial order. Please see the predicament. It has to be on the basis of persuasion, on the basis of collaboration, on the basis of the bar association is here, bar council is here. All of you join heads, sit together and resolve. We will welcome it. We can only ensure from our side to provide best of the infrastructure so that all members of the bar while sitting at home can join online, can argue and appear in their matters.
May I submit something?
If any member feel any difficulty, yes, we have to make arrangements for that. But it is
May I submit, my lord? As a head of the family, my lord, we are the strongest pillar of the society. If my lord would pass the order and my lord, what I am seeking only 3 months, 3 months directions, my lord. That's a temporary directions, my lord. 1 month is vacations, my lord. 2 months, we will contribute a nation, my lord, dealing with the fuel crisis, my lord. As a community, my lord, we should contribute, my lord. That is all I am seeking, my lord. A 3 months direction.
We appreciate your concern about to conserve petrol, diesel, gas, environment. All these things are there. We know parking issues are there. Members don't get, and particularly senior members of the bar are facing a lot of difficulty.
I'll give you one example, my lord. Yesterday, I was just going outside the court, my lord. 2-3 drivers, my lord, The lawyers were inside the court. They switch on the cars, close the windows, and then you're using the ACs, my lord. So the way, my lord, how the one hand we are dealing the crisis, my lord.
It's not the court command. It is
My lord, but
Gandhian
as
philosophy.
a head of the family, my lord, as a head of the family, if my lord may issue temporary directions,
Head of the family, I can only request, I can make an earnest appeal to the members of the bar, and this is what we have done through two kind of administrative circular. Those are also not orders, those are only administrative circulars requesting that please join us from home, virtual proceedings, but we cannot impose a restriction on the members that you don't enter the Supreme Court or you don't enter the court. That would be very difficult.
my lord, what I am seeking, my lord, the miscellaneous matters may be heard on the virtual mode, my lord. Only the effective hearing, the final argument, my lord, and the evidence. 3 months, my lord.
Secretary of the Supreme Court bar are sitting here. If not the president, chairman of the bar council is here, persuade them. Let the general body of the house resolve. We are ready to provide whatever facility members of the bar they want. We have no difficulty. We can, whatever assistance, logistic support from the Supreme Court side you require, we will definitely provide. It is our duty also. The members of the bar, the legal fraternity, particularly our young members who might face some difficulty. They are our future. We would like to invest in them. So if they need any kind of facility, we will provide them. It's a institutional responsibility, but very difficult to issue a judicial order and command that you.
My lord, I am not seeking any command, my lord. What I am requesting is only for 3 months. 1 month is vacation. My lord may issue notice, my lord. My lord may issue directions, my lord. That, my lord, miscellaneous matters would be heard online, my lord. The main matters, my lord, the final hearing, the evidences, my lord.
Judicial order, it is the Gandhian philosophy that will work. You need to go to member and convince them that the time has come, the high time that we should adopt this kind of measures. Not only these are not austerity measures, these are the measures for the keeping in view the future requirements, environment, daily weather conditions, facilities, and why members should face lot of hardship in coming all the way from their homes, challenge of parking. Sometimes some of them who might be a faraway place, in public transportation sometimes is not so convenient. All these, we understand the difficulty. We are with them, but we can only appeal like right now we have appealed to them. It is their choice.
My lord, I am submitting, my lord. If my lord would issue any direction or order, my lord. In fact, what happens, my lord, then trial district courts, my lord. Many of the judges, my lord, they don't entertain virtual hearings. They say ki for miscellaneous purpose you have to come courts, my lord.
That's why you must have read it. I have already written to all the chief justices of the high courts requesting that. And whatever feedback I'm getting on administrative side, that all of them are making endeavor. They have made sincere efforts. Some of them have very successfully. Like one bar association I know, wholeheartedly the High Court bar has resolved. They have decided that we will only join online. Welcome step.
Madhya Pradesh High Court, my lord, the judicial officers are going on bicycle, my lord. The Madhya Pradesh High Court, my lord.
See, weather conditions depend on road conditions, also depend on daily traffic, daily this when temperature touching 50, it may not be feasible for particularly the senior members or even for the young members to come on bicycle. It may, you see, let's be very practical, but good transport is can help there a lot. Or the best thing is online, no doubt about it.
Best thing is what? And during COVID period, my lord, we have developed the kind of infrastructure, my lord, and we can utilize that, my lord.
We have gone ahead in creating the infrastructure. Right now, there are no hiccups, there are no difficulties.
No hiccups, my lord, especially in Delhi.
Again, this is all to the absolute discretion of the members of the bar or whatever association and council they resolve. We are with them.
I live up to my lord.
We are with them.
I live up to my lord.
We appreciate the initiative taken by the petitioners through the instant petition, where they want to impress upon the members of the legal fraternity to join court proceedings through virtual hearings spoke online. However, it may not be prudent or expedient for this court to issue a judicial command to compel all the members to appear online without knowing the difficulties or impediments the individual members, especially the young members of the bar, might be facing. Consequently, we do not
deem it appropriate to issue any direction. However, the earnest appeal issued through two administrative circulars need to be reminded, and it will be this court will welcome each and every member of the bar stroke legal fraternity who decide to attend the court proceedings through virtual hearing, With these observations, pledge anything, sir?
My lord, there is one more submission. My lord, in Delhi only, 230 buses. Every day they come from the jails, my lord, carrying the prisoners to attend the day-to-day hearing. Prisoners, my lord, every day 230 buses are coming from all the prisoners, my lord. With them, battalions are also coming, my lord, for the security purposes. If they may be allowed to join the online, my lord, that would save a lot of, every time, my lord, 230 buses, my lord, from all the jails, my lord. The prisoners are coming to attend the court proceedings.
No, who got the officers?
No, my lord. Prisoners, my lord. They have, every day they have to come for the attending the court proceedings, my lord. If the jail authorities would make them appear through virtual hearing, my lord, at least we will save.
Can you give any instance of on administrative side? You please bring to our notice. If there is any, otherwise there are like we know in Punjab, we know Haryana, we know other states also. There are standing instructions. They are now appearing from jail online only, unless there is a hearing where some effective proceeding where his presence is required, then only. Otherwise, they are appearing online.
No,
But if there are
Delhi,
instances,
every day they are appearing, my lord.
if there is any other state where this kind of difficulty is coming, then please let us know.
My lord.
We will take up that.
My lord, the 14 days judicial custody, my lord, those prisoners have to appear every time, my lord, when the hearing comes, my lord, extended judicial custody, and during that period also, my lord. So if my lord may pass any directions for the 3 months that they may not be produced physically.
I will get the facts collected on administrative side and do something.
Deeply obliged, my lord. Deeply obliged.
May please, my lords. My lords, in this petition, we are seeking clubbing of FIRs because the cause of action is the same, the accused persons are the same, and the charges are also same. And my lords, multiple FIRs.
Of action are similar.
My lords, if I may just show page C. My lords, if I may just show page C, where I produce a table, there are 5 different states. So, for example, in Uttar
States does
Pradesh.
not matter. There may be 20 different states. But what was the cause of action?
Right, my lords. Absolutely. I bow down, my lords. My lords, a judgment in Amish Devgan, which has been laid down by this honorable court, very clearly says that even if there is a cognizable offense, which an FIR has been filed, anything that is which falls beyond that, that can be investigated.
It falls beyond that. Each and every victim who is misled by your misrepresentation to invest in your cloud structures or cloud equipments,
yes, madam,
is an independent cause of action.
My lords, may I just show page C?
Nothing to do with a
I
continuation.
bow down to what my lords are saying. May I just show page C, my lords? Because the charges are mentioned, they are verbatim, my lords. Exactly the same charges.
If let us say you come into a room and you commit dacoity here, and then you go to the other house and commit dacoity in another
Lords, that is not the case. In fact,
well, that is the case because the word dacoity is feeling harsh on your ears, but the sweet noise of deception makes it the same act. No,
my lords, in this case,
they are
what happens
completely
is
independent acts,
the
and
Uttar
these
Pradesh
acts can be acted upon independently. The provisions of law with regard to clubbing are all enabling. They are not jurisdictional.
My lords, in fact, I bow down to what is falling from my lords. The FIR, the first FIR, which is the principal FIR in UP, in fact, takes into account the subsequent commissions of the offences in different states already. So, therefore, my lords, all of these offences, which
will be filed, we will consider.
My lords, in fact, the prosecution complaint
When
has
the
been
charge
filed.
sheet will be filed, we will consider
My lords, if
whether the initial charge sheet includes the other acts of cheating or not.
My lords, if I may just show one thing.
This is the consistent view we are taking every day.
My lords, may I just then seek withdrawal and try and approach the parental high courts, my lord?
Yes.
And seek that liberty there, my lords.
After arguing case for some time, and consider the petitioner seeks and permitted to withdraw this petition with liberty to approach the jurisdictional high courts for appropriate relief.
Obliged, my lords, greatly obliged.
We are coming back. We have a common lunch today.
May it please.
Item 20.
May it please, Manoj. Manoj, this is for clubbing of FIRs. Manoj, there are 4 FIRs in 4 different states: West Bengal, Tamil Nadu, Kerala, and Karnataka. Now, the allegation is, one, Vikas Ali, my lords, had actually lured people to invest some scheme. How I came in the picture, my lords, I was actually a small businessman in Tamil Nadu, my lords. One, Mr. John Yami contacted me that with regard to some business transaction, my lords, and that's how some money came into my account. Today, I am ready to cooperate, my lords. I am requesting my lords can consider consolidating in one of the, and the allegation, my lords, is of one Mr. Vikas Ali. If my lords will see the allegation, all the 4 FIRs. He asked them to deposit in one scheme some Stonewall Capital .tech, my lords. If my lords will just see the allegation, all the 4 FIRs.
Our problem is that consistently we have taken a view about on this issue of.
But my lords have,
if you want,
there are 2
if you have your own narrative
Please.
as a plea of innocence that you
Please,
are.
my lords.
Are you on bail in this matter?
My lords, I was arrested for a few days in one
case, he has been made at you.
Here in bail and all the matters. I have not been arrested.
You can protect your arrest to the subject to the condition.
Please,
that you go, give your version.
Absolutely, my lords. We are absolutely ready to cooperate, my lords.
Let them investigate.
Yes, yes.
If they find it so, like otherwise clubbing, we are not.
Very well, my lords.
So the petitioner, she is a woman.
My lord, she is a woman, my lord.
That is the reason that.
My lord, I must be fair to the court. Earlier, husband and wife had filed a petition, but they had different prayers, my lord. That would be there in the office report. Today, I'm asking for clubbing, so I have to be fair to the court.
That is there, that.
Yes.
The petitioner has approached this court under Article 3 taking a direction for clubbing and transferring several FIR closed against her for alleged cyber fraud committed by the petitioner and her husband. Tiruvannamalai district in Tamil Nadu, and they are directors to partner in 3 trading companies based in Chennai, namely Shivam Traders, Kavisri Agencies India Private Limited, and Shri Kanak Dhara Spirituality. The petitioner has a long story to tell as to how her husband was introduced to one John Yami through a business associate, and how her husband bona fidely entered into some commercial transactions under a scheme which eventually was found to be online investment fraud operated through a platform called Inverted Commerce Stonewall Capital. Inverted Commerce was promoted by one Ali Vikas. In some instances, several FIRs have been registered against the petitioner, her husband, and other co-accused. The details hereof are given in the.
Because I'm not named in the FIR. My bank account, I am not named in any of the FIRs.
Have been registered against the petitioner's company, petitioner's husband, their companies, and other associates. So the petitioner is not named in those FIRs. We have heard Rahul Kachil and Senior Counsel for the petitioner. Though we are not inclined to entertain the prayer for clubbing or transferring the FIR before one investigating agency. However, having regard to the fact that the woman, semicolon is not named in the FIR, and she has her own version to claim innocence. We dispose at this stage by directing the states of so and so not to take any coercive action against the petitioner for a period of 1 month, 2 months, 2 months, subject to the condition that the petitioner shall immediately join investigation in all the states, before all the state agencies, and shall be at liberty to put up our explanation, which may also be dispassionately investigated while taking the ongoing investigations into a logical basis. Please clarify that we have not expressed any opinion on merits of the case.
So grateful, Manoj.
This is very business. Huh?
Sir, please unmute yourself. Rakesh sir, please unmute yourself. Sir, there is some issue at your end, sir.
This is also advised by the High Court for appropriate relief.
22. Please, Your Lordship. Lordship, with great respect, I beg to submit that there is a palpable violation of the fundamental rights, which has curtailed the petitioner's legitimate expectations of fair trial in the matter. And there is no gainsaying that fair trial remains one of the constitutional guaranteed right under 2021. Now, if my lords look into the grievance of the petitioner, there are many documents which ought to have been taken by the investigating agencies which would have unraveled the truth.
What is the stage at which those documents are to be taken into consideration?
The documents, because
Document which is a defense document, you say that you had paid money, there is a receipt, you are not a bogus customer against which a loan which has been misappropriated had been advanced, right? Now, these documents, according to you, are impeachable in nature and give a clear answer to the accusation of conspiracy.
grateful lordship.
Now, our query to you is,
Stage.
at what stage will the courts take cognizance of these documents?
At the stage would
And
be
whether Article 32 is a jurisdiction which can be invoked for this purpose?
now, Lordship, Article 32, Lordship, there is a recent judgment of Rajendra Bihari where the Honorable Supreme Court has taken
That
a
trial will be held under Article 32?
No, not trial will.
So this is exactly what you are asking us to do?
I'm only requesting.
Tribal versions to be considered in Article 32?
Now, Lordship, my only submission for kind consideration is if those sterile evidence are.
Devendra Padhi overruled by this court?
No, that
Devendra
holds the
Padhi
field.
has not been overruled by
That
this
holds the field, Lordship. Defense document to be taken.
No, you know the law better than anyone.
But then there is just one impediment. Please consider,
Filed
Lordship.
against
There is one.
CBI report say that you are the kingpin of this fraud. And
But that is a problem, Lordship. Now, there is one legal impediment, Lordship. Now, as far as the builder is concerned, he has filed an SLP with the prayer for consolidation of the charge sheet. This Honorable Court has been pleased to issue notice in that matter. That is at page 365. At the highest, Lordship, may tag this matter.
No way. No. In all probability, that SLP, we cannot forecast its conclusive order, but doesn't have much of a good astrological prediction before this bench.
Then, Lordship,
If they are impeachable document, attach them large or for 482.
Lordship, I'll miss this
pending. My brother has rightly said.
only at the stage of defense evidence 3193.
Yes, so you
But
know
then,
it.
Lordship,
Well,
but then
when you will adduce the defense evidence.
please consider, Lordship, the valuable right for an accused arises when I move a discharge application. Those documents I cannot even show to the London magistrate.
So we again asked you, is Devendra Padhi overruled?
No, Lordship, that is holding the field.
Then we are following Padhi.
In fact, Satish Behra's case stands over.
Big or small, every accused has a right to say the same thing.
Mini
First
trial.
32
We
courts
can't
will
have a mini
scrutinize.
trial at that stage.
The Lordship, I could be permitted to wait. And
So sometimes National Council for the Petition seeks and permitted to withdraw this petition with the liberty to waive all the contention before the trial court at an appropriate stage.
Grateful watch.
Item 40,
My lords, we are just seeking a small clarification.
your mind.
The reference court, my lords have said compensation, the rate is fixed. And
Compensation along with statutory interest.
yes, what the reference court is doing is it has granted to an amount which according to us should be about 3 crores.
Before the High Court.
My lords, they are drawing sustenance from my lords. I'm just looking for a clarification.
Solution. The landowner is entitled to solicit, can't be any doubt.
No difficulty.
Interest rate is prescribed because it's under
Section
the old Act,
28.
therefore 34.
That's right, my lords. But what the reference court has done is it has granted it at the rate in 28, but compounded it. So the amount which should be around 3 crores has become 8 crores. That's our limited problem, my lords.
My learned friend perhaps incorrectly speaks of interest, not interest or interest, separate interest, not in, and that was the judgment already given in that 1994, and that same judgment is being carried out here. No, my lord, I just want few seconds. In their petition, the MA petition, they have stated there was an order by the reference court calculating an amount of 4 crores 44 lakhs.
We are not going into that.
Yes, no.
I'm not on
the point.
I just want to clarify what I'm saying. My friend is
followed your contention. If there is a defect in the computation, it would be subject matter of an appeal.
I'm not on the defect in computation right now, my lord.
But I will submit that in that petition they have stated that they were
judgment for refer.
In that petition, they stated they are ready to deposit these 4 crores 44 lakhs. What is submit is that? Let them deposit that amount at least. Litigation has entered 38 years of its existence. And at one point of time, there was subtle service between of this matter from Guwahati to this honorable court and the honorable court to Guwahati court. So let us stop somewhere and sometimes.
Trying to achieve.
Reference court is awarding compounding interest.
No, I don't think so.
No, it's not a question of thinking so. I'll show it.
Their only contention is that 10% additional interest given on the total amount. That point has been.
I'll just say one thing, my lords. My lords have said statutory rate of interest, which is nothing but section.
What according to you is the admitted award amount?
According to us,
44 lakh.
the admitted rate of interest would be 15% from the second year under
Very
28.
good. What is the admitted award amount?
The admitted award amount, as per our computation, is
4 crore 44 lakhs.
2 crore 99 lakhs, which is at page 4.
With interest,
Along with interest, according to us, on simple interest, it comes to 2.99 crores. We have explained how we get to that figure also.
so like, have you paid and deposited this 4 crore 4
2 crore 99 minutes. That we will deposit. There is no difficulty. That we will deposit because the reference court granted. I'll just, if my friend gives me 1 minute, I'll just clarify what I'm trying to say. Initially, my lords, the reference court had computed about 4 crores. Thereafter, it revised its own order and increased it to about 7.9 crores.
We are saying, so your problem is only from.
My problem is twofold. First problem is that they have given us compound interest. They have awarded compound interest in place of simple interest under 28. Secondly, over and above what is the section 28 interest, they have added 10%, saying that because of delay, from the date of the reference court order till the date of payment, 10%. This again is nowhere in the act, my lords. That's our submission. Whatever is 28 interest, my lords may record my statement, we will deposit it. And that according to us is 3 crores. If according to my friend, interest computed under section 28 is something more than 3 crores, he can tell us, we will deposit.
In any case, if the reference court goes beyond that, you challenge that order before High Court.
Today, my lords, they are deriving sustenance from the fact that my lords have upheld the order. So nobody is now then revisiting that question.
Yeah.
Could my lords leave it open saying that what this court has awarded is interest under 28? That's all I want, my lords. Then we will take it forward.
Submission, we will file response to that also.
This miscellaneous application has been made, seeking clarification of our order dated February 18, 2025. Hereby civil appeal number 1367-1368 of 2018 were allowed and disposed of in the following terms. Next paragraph. According to the IOC, that's beneficiary of the acquisition, our total compensation as per our order comes to 2 crore 99.
That 2 crore 99 includes this 10%, my lords.
Crore 99.
2 crore, I'll give the 299. I'll give the exact number.
That is that
299.95.
calculation, not our calculation.
My lords, 299.95,703.
03, which includes the statutory interest at the rate of 15%.
Compounded plus 10% on the delay. They have done two things. Neither of them is in the act.
15% can't be compounded. 15% is statutory interest.
That's right, my lords. But what has been done is it has been awarded compounded.
Statutory interest, upon which 10%
further has been added.
Interest has been added on account of the perceived delay.
My lord.
On the other hand, Senior Counsel for the landowner states that the landowner company states that the reference code rightly enhanced, rightly refixed the compensation amount to the tune of 7 crore 89 lakh 76,349. 349. Definitely entered. Solicium.
Solicium is included. If my lord sees page 43, solicium at 30% is included in the compensation amount. If my lords have annexure A5, page 43, on that we are not in dispute. We are only on interest. As my lord have the fourth line on page 43. Solicium at 30% is included to reach the compensation amount of 61 odd crores. That is, on that we are ad idem. That 61 lakh figure is not in dispute.
I think this report is doing some mistake.
The issue starts thereafter.
Additional solicitors are here on behalf of the IUC and the Senior Counsel on behalf of the member.
12%.
And we will report next paragraph. Our order 18th February 2025 is quite clear. In addition to the is quite clear, the respondent landowner has been held entitled to compensation as was awarded by the district judge Kachar from Silchar, wide award dated 24th December 2001. This would mean that the landowner shall be entitled to pay the amount of compensation as may be determined in accordance with section 23 of the Land Acquisition Act 1894, that is the award dated 24th December 2001. 2I, the solicium at the rate of 30% per annum in terms of section 23 in bracket 2 of the 1894 Act. C, the additional amount at the rate of 12% per annum as per section 23 in bracket 1A on the amount of compensation calculated under section 23 in bracket 1 of the 1894 Act. Next paragraph. As then fourth element, interest. Next. Now next main paragraph. So far as interest is concerned, section 34 of the 1894 Act is leaves no room of any ambiguity. The rate of interest as prescribed in the statute for the first year from the date of taking possession of the land shall be 9% per annum, and thereafter till the amount of compensation is paid, such rate of interest shall get enhanced to 15% per annum. Next paragraph. As there is a serious dispute with respect to computation of the interest component, we direct the applicant petitioner IOC to deposit the undisputed amount. Have you deposited?
We will deposit it, madam.
To deposit the undisputed amount within 2 weeks, which shall be immediately released unconditionally to the landowner without prejudice to the rights of the parties.
In the name of the company. In the name of the company. Demand draft.
Respondent.
Company landowner.
Landowner is a company in this case.
Thereafter, the reference court is directed to redetermine the interest component in accordance with section 34 of the 1894 Act, approving both sides. If both sides, the aggrieved party, again, the party aggrieved by such determination shall be at liberty to approach the High Court.
Lords, 4 weeks for the deposit, my lords.
Oil company, you can blame.
just but abundant caution, my lords. We'll try to do it before that.
Unless it will delay only 4 weeks.
My lords have said interest under section 24. That might be section 28. 34. Yes.
34. 34, not 24.
34.
30.
I'm obliged.
Old Act, old Act.
Old Act, yes. Obliged.
Wait, please, Your Lordship. Your Lordship, SEBI has filed an appeal against this very same impugned order. Against this impugned order, SEBI has filed a cross.
Here the SEBI appeal, why your appeal?
Yes, Your Lordship.
Why your appeal?
Your Lordship, this is again the common impugned order. SEBI has filed an appeal.
You are against the SEBI.
Yes, yes, Your Lordship. Your Lordship, in this matter, what has happened is that a non-executive director who was a retired
non-executive officer in default.
Your Lordship, he was a retired general. SEBI has not.
Officer in default.
SEBI.
Under section 5 of the Companies Act.
Your Lordship, SEBI has not established the foundation.
You are the person who issued the power of attorney to the Companies Act.
I was not even a
for
director.
Publishing the.
Your Lordship, I was not even a director at the time when the red
Documents
herring.
are found to be signed by you.
Yes, Your Lordship.
All relevant documents are found to have been signed by you.
I was not even a director. Your Lordship, the SEBI show cause notice was issued 17 years after the proposal was.
The other debenture case before the Supreme Court was disposed of.
Your Lordship.
And all these points have been decided. A, that your point that you're covered by subsection 3 of section 67 has been
Your
negated.
Lordship, I'm not on the merits. I'm only on the individual
Not
liability.
in the merit, why
Your Lordship,
you
I'm
don't
on
make out a case on merit, why we will give a.
Your Lordship, I'm on the individual's liability in this matter. Individual.
It's not an individual liability, it's a statutory
Your
liability.
Lordship may kindly have the impugned order. Your Lordship may kindly have the impugned order. There is no individual finding against me, either in the SEBI order or in the. Your Lordship, connected matter is pending. Your Lordship, connected matter is pending before this.
This is your best point that your opponent has done.
What is the date?
Yes, Your Lordship.
In the connected matter, what is the
Your
date?
Lordship, it's not reflecting a date as such, but it is reflected in the office report. In the office
So
report.
let me find out and then list both.
My lord, may I just point out two things, my lord?
We are not.
Only one
deciding anything.
submission.
We are not passing any order today.
The fact that he was the one who signed through his power.
Sir, have we issued a notice?
No, my lord. But the other matter, my lord, is against that the SEBI appeal, my lord.
We are
We want
tagging
examine
this
material.
matter.
I'm just submitting that the SEBI appeal is against appeal number 251 before the SAT, where they let off the
The company secretary and the manager.
Yes, my lord.
We've seen him.
So that is
No,
nothing
that's
to
why
do
we
with
told him that there is
Lordship.
no similarity.
Who is item 42?
Grateful, Your Lordship.
Lordship is just taking it up with the other matter.
Yes.
Obliged.
No,
Grateful.
please.
Item 42, please. No, it is that.
If it may please, my lords, this is a gaming matter. Post-assessment order. My lords,
The order has been passed. There are two types of stay order we are passing, where the notice has been issued only or where the order has been passed. The order is not to be executed.
my lords, I'm carrying a copy of the order that my lords passed on 15th.
This time no coercive action will be taken against
My lords, there's a small request. Different financial year, I have also been served with a different assessment order. So those that matter is also pending before this court. So they may be tagged.
the very bad. Taking up together.
Right.
Item 44.
44, may please. This is an application.
Also notice.
May I take
45.
May I take Dusty also, my lord, please?
Let Dusty also.
Great.
Tell the postmaster.
Yes, sir.
Even after not much obliged. Stay of the proceedings. Much obliged.
Lord, these are several matters which require, my lord, intervention of the court. It's a pan-India circular is issued, my lord, by CBSE. Just want to tell you, my lord, in a nutshell, without reference to papers. Without reference to papers. So, my lord, let's say Delhi. Somebody studying, my lord, English, Hindi, and say French. In Bengal, my lord, somebody studying English, Bengali, and French. In Tamil Nadu, similar. Now they've issued a circular. First, they said we will implement a change from 2029-30, which is about 3-4 years away, my lord, so the students will adjust. But suddenly, it is now, my lord, made a change to be, my lord, launched now on 1st of July, which is in the ongoing session, which children have been promoted, they're already there in April. In the ongoing session, in the 9th standard, my lord. All India, now the mandate is you must have 2 native languages. So let's say, my lord, Tamil Nadu. Somebody who studied, my lord, Tamil and English and say French, because you don't study Hindi, a lot of people don't. So he will have to have one more native language in the 9th class when he's already 14 years of age. He will have to take Telugu or he can take Assamese, he can take whatever he likes, provided you have teachers. In Delhi, my lord, we studied English, Hindi. So now, my lord, that's not enough. So one more thing I want to tell you. Not something startling. They say we don't have textbooks because you have to implement in 15 days. Take the textbook of 6 standards and teach somebody.
Are you there in this matter?
Also raises some constitutional
These
issues.
are very, very important issues.
Legal aspect, we will see whatever it is, but there are certain factual aspects of logistic
Issues
implementation issues. We would like to have your comprehensive reply, and we will take up the matter on 15th June.
Yes, but my lords are sitting here. I'm very grateful. Very grateful.
Teachers will be a problem, man.
These are issues, Malad.
See, not
Language.
create a chaos for the youth.
There is two
Malad, I-
constitutional issues, one of federalism and one of choices.
People can be salutary.
Yes.
The policy, one
We
principle.
will do it from 2030.
No,
Even
even
they have said, can't be tomorrow.
But we appreciate the logistic issues.
And
Now, I understand the logistic issue, but there is also a question of choice, Malad.
Malad,
Language is a matter of choice. I can understand you can say that, look, there's a national language, you must learn that. Of course, we must learn. But otherwise, language is a matter of choice. And also federal issues.
Simple, we're not really on the question of federal issue here, because it is an insistence on federalism in the country itself.
No,
By
but
increasing the number of national languages.
anyway, I'll leave it at that. Malad. There are issues we
can you
It's not a federal issue.
Correct.
It is an issue
I am-
of being unreasonable. When an
it will be arbitrary.
That's what I said, Malad. It's a matter of choice, Malad.
When
That's why.
teachers are not there in the school,
That's right. That's the procedure.
syllabus, books are not there, whether it would be.
Well, a third language has to be introduced in class 6. Can't be introduced otherwise. Anyway, Malad,
For 9, he says,
several other.
because they don't have books for 9. Read the books of 6 for 9.
Right.
Malad,
Anyway, Malad, the Lordship may take it up on 15th June.
issuing notice, I will file.
There are some additional.
Put in a reply, my lord. You have seen it.
Malad, I only request
yes.
your lordship may have it in July, my lords, but so that we can assist you. My lords, there is nothing, I can assist now also. There is nothing happening in July, my lords.
Madam, it is effective 1st July, my lord.
You can postpone it.
You either postpone it.
Postpone it, that's all.
My lords, then permit me to assist today. I am ready today. I'll assist your lordships today.
You can assist now if you want.
Very good silver lining that there is no exam. It is because they also don't want.
There's an internal assessment. That's also wrong.
You need not give an exam in the 10th class, but your final certificate, which is
Will be reflected.
must show that you have passed it.
That's right, Malad. So that's the problem.
That's another problem.
Yes. You have to pass the exam. It won't show in your final score, Malad. You have to pass it.
You won't get a certificate for the 10th unless you pass it.
That's correct. So that's the
It will be
problem.
counted in your.
My lords, I am ready today. I can assist your lordships.
No, but
And
because you will give one part to the other.
yes, my lords, but I'm requesting, my lords, just there is no urgency for 15 June. Only the classes will start. Your lordships may have it in July. Your lordships may have it in July, my lords. Nothing will happen. It will all be subject to your lordships' orders if you are not able to
Please.
satisfy the
They are saying we will implement from July 1.
My lords, only
How can we
classes
wait
will
your
start.
like-
My lords, your lordships will have an opportunity to see how the classes have
They
started.
will implement only when classes will commence.
My lords,
Classes have commenced in April.
Mr. Rohati,
July.
there is the class commencing. Do the schools have adequate number of teachers?
They don't have.
Oh, they don't.
So let madam give a status report in July with regard to their logistics.
Lord, this is a.
Help us out with all of it.
Lord, I wouldn't have said no, but it affects every student in this country. 4 weeks, 3 weeks from now is 15th July. My lord, your lordship's bench is sitting. Why don't we have one hearing in 15th, 16th? Then your lordship will take it forward.
Let them also get the All India feedback.
Yeah.
On the opening week, one day, we will not list other matters. We will have only few fresh matters. I will take up this matter.
I'm grateful,
File the reply and get the information.
I will do that.
There are issues of hardship,
Yes.
inconvenience,
Yes,
difficulty, lack of logistic support,
yes, my lords.
which have been raised here.
Please, my lords.
On the issue of language, somebody may say that when you learn more languages, you strengthen federal structure. Somebody may say, no, it is.
No, it's a matter of choice according to me.
State's power.
That's an issue that needs to be addressed.
No, because they should hold their horses.
Both ways, correct, Malad.
They should also hold their horses.
That's right.
Till your lordships are hearing it.
Main thing
Even if
is
there is
all
no
fair
intent
and
order, please hold your horses. The lordship may hear it, no problem.
All, whatever is may be, the issues need to be addressed.
I bow down, my lords. We will satisfy your lordships on how the policy is on what merits, how the transitional provisions have actually catered to the convenience, the comfort,
of the students, my lords. There are students. There's no question of, my lords, making
Take up on the
it hard on the students.
in the opening week, maybe around on
1 second, let my lord just say something.
15th or 16th July, we will take.
Very well, very well.
Make sure that other matters are.
Very well.
Copy as well as hard copy of the petitions be handed over to in the office of Madam S. Additional Solicitor.
My lords, only soft copies, my lords.
Only soft.
Only soft, my
Very
lords.
good. Only soft copies may be handed over. And will you be representing NCRT or NCRT?
I am appearing for NCRT. I am being led by Mr. Solicitor General.
Council and Council.
Thank you so much.
By tomorrow, soft copies. The counter affidavit filed within 4 weeks with advance copy to learn Council for the Minister. So and so petition, Mr. Sibbal has pointed out from the petition, we also beg along with this.
But there's a very number which may also be tagged.
One matter, one urgent matter.
Implement the policy.
All of you can give your petition. Those will be taken as notice.
Fair enough.
Lord, one urgent matter, item 50.
We are coming to all urgent matters, just wait.
Lord, oh.
Malad, item 3 may be taken up on Friday, Malad, item 3.
Fresh bail.
Fresh bail, Malad, be taken up on Friday. It was passed over, Malad. It's a bail matter, kindly take it up on Friday.
There is gross filing.
My lords, in fact, what has happened is on 30th of June, my lords, on 30th of June, in fact, the schools have to implement this and direct them. So therefore, if they can just hold their hands, my lords, one line in the order will go a long way to protect the interests of the schools and teachers. And
we are issuing notice, please keep
My lords, item 54.
Keep your arguments and issues resolved.
that's the only requesting.
Presentation, we will see what.
We will, my lords, but they will not make the policy implemented.
Please send it through representation to.
We already have, my lords. In fact, we put that in the
have an additional ground on that date if they want.
My lords, item 54 is the appointment of DGP for Manipur, my lords. We have filed an application.
We are coming to that. We are coming to that. I know that I'm hard pressed to find, but then. Your item.
3, Malad, your lordship may have it on Friday. Thank you.
Your lordships, if I may please.
May I mention item 29, my lords? This is a 20.
Yes.
Item 47 and 49, please.
47 is a bail application. I am a person who was 9 years in custody, granted interim bail by this honorable court.
Let him go and appear and take regular bail.
Because I have,
Take regular bail, Mr.
No,
Agarwal.
I'm so sorry. I'll just let me indicate what has happened. I was a person when this honorable court directed registration of FIR. 9 years, 9 months I spent in custody. This court granted me interim bail to say.
To appear before the jurisdictional court and take bail. Your grievance is now, this is a law where anticipatory bail is not available.
In fact, your lordships have said this law does not apply in my situation. And your lordships have granted me protection till 15th of July. I'm only requesting, please have it in the first week of July. I'll place my case.
In the daytime,
I'll
try for regular bail. Go apply for regular bail. In case you are granted regular bail, your stress is over. If it is not, then you press before us.
Please, brother. Please have it in the first week of July.
We take up on 15th or 14th.
15th is the date by which your lordships have protected. Any time up before 15th.
We take on 13th itself.
I'm mobile.
Okay.
Which one?
You're mentioning 54.
Would your lordships indicate there that this will, I'm so sorry, would your lordships indicate it will not stand in my way to apply for regular bail in the meantime?
Exactly.
Otherwise, the learned trial court will.
Meanwhile, the petition said we are at liberty to seek his enlargement on regular bail.
I'm most.
Well, National Judicial Academy has sought 4 weeks time.
4 weeks time.
Yes,
we are granting, Mr.
Yes, madam. So great.
We are granting 4 weeks time. What happened to other urgent matters?
53, my lord, I was asking.
My lords, item 33 is the digital arrest case. My lords, may I mention item 33?
Later on, not right now.
They have taken away my paper books. They want me, for force they want me to now. कौन लिस्ट दे दो मेरे को? 53 सर डेट That is pending before the High Court.
Patna High Court.
My lord, the quashing is pending, but my lord, there is a serious danger to the life and liberty of the. There is purely a civil case. It's my property.
Well, let's say the petitioner has approached this court. Please, because I don't have paper book, I'm only trying to recollect. Petitioner has approached this court under Article 32 of the Constitution. Seeking quashing of the criminal proceedings arising out of case number 161 of 2026, registered at police station, Kochi, district Swansea, district Gopalganj. The aforesaid case has been registered under section 329(3)3084 of the Bharatiya Nyaya Samhita 2023 and section 27 of the Arms Act. Next paragraph. The petitioner is a member of the Bihar State Legislative Assembly who has been elected 6 times.
6 times. This is the 6th time.
Collectively elected on 6 times. And extortion how many times? It seems that there is a property dispute. There is a title dispute between the petitioner and his family on one hand and private respondents on the other. With respect to which title suit number 255 of 2024 and title suit number 662 of 2024 are pending before the civil court. What is the date when your father purchased this land through sale deed?
1978, September 1978.
The petitioners are said to have purchased the case of the petition that the subject land was purchased by their father, bought by their father, way back through registered sale deed for consideration, way back in September 1978. However, the subject cases have now been registered against them, alleging various offences that have been committed by them. Next paragraph. It is now fairly admitted by senior counsel for the petitioner that a question petition filed by the petitioner is pending before the Patna High Court. The High Court, there being summer vacations, the apprehension of the petitioners is that the petitioners apprehend coercive action at the hands of the police, even though their question petition is pending before the High Court. Also, taking into consideration all the attending circumstances and without expressing anything on merits, it is directed that no coercive action shall be taken against the petitioners pursuant to FIR number, FIR number है 513900826061 of 2026. Until the matter is taken up for the effective hearing by the High Court. Meanwhile, we request the High Court. Meanwhile, the petitioner is directed to no appropriate application before the High Court for early disposal of their pending petition. We request the High Court to prioritize the hearing in the matter and pass appropriate orders. How it is clarified that we have not expressed any claim in matter.
Lord,
item number
of,
29.
Word dismissal that will be maybe disposed of.
Disposed of.
Item 53.
Lord, there were 2 petitioners, my lord. The petitioner.
One is brother.
So item number 29. Item number 29.
Well, also item 40 was not called out for some reason.
There are a batch of matters of Bihar.
Well, also I'm in one of them, item 43.
So, probably these are matters which are otherwise broadly covered by our.
My lords, they are, but my matter, I pointed out that my lords had given the operative directions of having presence of 2/3 members at any given the meeting. Now, they are not 2/3 members, and yet the resolution's been passed and the election for that the body is to be held on the 10th of June.
I was trying to read in the only additional point appears to be that where the no confidence motion moved, meeting convened, no member comes, requisite members don't come and the motion fails.
Please, my lord.
Now they are saying that no, this motion will not be treated as a motion, again there will be called.
My lords, in this particular, in my matter at least, but now there are guidelines which have been issued by the DM. Those guidelines have a requisition as per my lord's order of 10th of February that the motion, when it is to be moved, at least 2/3 of the members must be present, because they were brought in two issues. One was the quorum issue and other was present and voting. My lord said that so far as present and voting is concerned, that's not the correct view, because the statute requires there should be half of the elected members of that body. Now, that's one aspect. The other one is what is the percentage that is required. On 10th of February, my lords had passed an order which Bihar has reproduced in its directions to all the assemblies, that there should be 2/3. Now, my lords, here 2/3 is not present. They have passed the resolution.
So those are annulled now. How can there be? If 2/3 is not present, those resolutions are void of an issue.
My lords, but then now they have removed me and they're holding an election on 10th of February, on 10th of June.
We will pass
My
the
lords,
order.
therefore I'm saying my lords may take
We'll
it.
pass the order wherever इसमें add कर देंगे. We'll continue.
Just they pass.
My lord, in one matter, connected matter, my lord, in my case, my lord, this no confidence motion was passed.
Argue, then we will take up on some other date.
Yes,
My lords,
because in
my
this
lords are
case,
passing an order.
no confidence motion has already been passed.
Same thing here. Item number 29. I'm being led by Miss Rekha Palli. She's trying to get herself unmuted because there was an urgent prayer.
Lords, I've just been, my lord, this is the application my lords had permitted directed registration of home buyers, my lords, within 3 weeks. Now, because the IRP has said he can't join. He said he will not be available.
We'll consider that. Yes, I got.
Now,
In Bihar matters, are my lord keeping it
Manipur's-
for Friday or my lords are passing an order?
Manipur's application, my lords. Our DGP is retiring on 31st May, my lords. Yes, my lords. Your lordship may.
This has a peculiar problem. Your lordships may grant. I'm for the respondent.
Allow outside. Say, prayer in this application is, say, this application has been moved by state of Manipur, pointing out, I say briefly narrating the unprecedented ethnic and civil unrest that has taken place in the state. The Director General of the Police, say, Mr. Rajiv Singh IPS of Tripura cadre, was appointed as Director General of Police in Manipur on 2nd June 2023. His term is now expiring, or he is.
Its term is coming to an end on 31st May 26.
His term is coming to end on
31st May 26.
on 31st May 2026. In the peculiar facts and circumstances prevailing in the state, the prayer has been made to permit to appoint the Director General of Police from outside Manipur cadre. So we find merit in the prayer. The same is allowed, and the state of Manipur is permitted to appoint the Director General of Police from outside Manipur cadre, initially for a period of 1 year. Let us see their situation for a period of 1 year. If the situation,
My lords, let it be a regular appointment, my lords.
Lord, the difficulty we find,
casting yourself 2 years to know. 2 years to know. 2 years to know.
Lord, apart from, Lord,
Permitted to appoint 20.
apart from the position, the difficulty we find is in Manipur, we as central government, my Lord, from amongst the eligible candidates, my Lord, we are not getting a person of that competence, my Lord. That's the difficulty. I should not say this, my Lord. but
It's in the
practical
Bihar matters, are my lords.
The very small state, my Lords.
2054 itself,
Item 55, this was.
Yes, my lords, these are applications, my lords. These are some projects, my lords. I've made a chart of these 5 applications, if your lordships will have, my lords. 2 projects of railway, 2 projects of NHAI, and 1 is of terminal for Agra Airport, my lords, additional terminal.
Any opposition?
One is NHAI, my Lords.
Yes.
I am appearing in same set of matter, your lordships. There are 5 IAs filed by the authorities in the Mathura, Vrindavan for expansion and the broadening of roads, your lordships. And in some of them, the SEC report has been came in. For an example, IA number 108684. There in that permission has been granted, and we have filed a compliance report as well.
My lords, serial number 4 in this chart will have to be referred to CEC. All others, your lordships may consider allowing,
And-
subject to the conditions that.
And as far as the IA number two report has come,
Yes, my
there
lord.
is no objection. We are allowing.
This is here, let it be subject to the conditions.
Learners Vicus will be.
So my lord, I have a chart with respect to all 10. You have to
And
Forestation has been done, that has to be affirmed by the CEC. So your lordships may say subject to. Yes, my
My lord, I am, for example, I am for NHAI. My lord, I don't think the project would be delayed by 1.5.
See, Friday is.
If your lordships,
Burden.
if your lordships may permit,
My lords, we are only requesting for these 5 IAs, 2 my lords NHAI. These are 2 highway projects, one from Gwalior, Agra Gwalior, one is my lords, the second one, Greenfield project.
Is there any issue? Is there any issue with respect to the IAs moved by the NHAI?
Subject to the conditions imposed by the CEC.
Yes, lord.
That can be, of course it can be, yes.
We appreciate it. So subject to those conditions, you all like. Obvious.
It can be done and we can stop, my lord, if it is not done.
My lords, that.
if your lordships may be permitted,
Wherever the, what we will do is that wherever CEC report is still awaited, we will seek the report, one. Two, where the CEC has accorded consent subject to certain conditions. Exactly. That has to be. We will expressly incorporate those very conditions in the order. So.
Yes, no difficult.
Has to be started. Now, whether the afforestation has been carried out has to be re-verified by the CEC.
That might take 3 months, my lord, while wait for a public project to start.
That will be taken care.
my lordship,
Item 43, which I had mentioned the Bihar matter. My lord just paused it in between. My lords, I either have my lords passing an order or my lords keep it on Friday.
All those matters where you feel that requires urgent hearing, you can give the consent for 15th June week. We will list those matters, otherwise we'll go in July.
My lords may keep it on Friday.
1-minute matter.
My lords may keep it on
Miss
Friday.
Rekha Palli is leading me in the matter.
My lords may keep it on Friday, my lords, item 43. 43 can be kept on Friday.
My lords, item 29, my lords, I've been wanting to mention.
What?
I'm sorry.
I request for 13th of July.
No, this is a-
13th of July.
This is home buyers matter.
We will list on 15th June, 16th June, 17th June. If there is, feel that there is no urgency till July, we will list in July.
My lords, my problem is 10th is the election. My lords, in my matter, 10th is the election. My lords.
Please, we have given you options.
29 your lordships only a direction.
My lords, election is on the 10th, so I.
ठीक है, ठीक है, let it.